regarding item number 298 of the monthly list. This is my
Upgradation.
expeditious hearing. Yes,
Upgradation, please come next Monday. Mentioning is only on Monday.
My lord, may I have
My
my
lord.
lord's leave to mention from the urgent determination of my lord Justice Sen, my lord.
Yes.
My lord, the date of demolition of the petitioner shops had been fixed on today, 11 a.m. My lord. My lord, the matter was scheduled to appear before my lord Justice Sen today, but it is not appearing and my lord is not sitting.
It's not appearing.
My lord, in my lord's list. My lord.
Who is appearing for the respondent?
My lord, I'll find out and serve a notice, my lord.
Is server notice? Yes. Hand over the slip.
But item number 50
2
of
p.m. Yes. Please come on next Monday.
item number 50 of today's list, my lord, your lordship heard this matter on last Thursday. Mr. Minal Kanti Ghosh appeared. My lord, your lordship fixed the matter today. Item number 50. Probably it will be not reached, my lord. Monday, Friday is the date for argument. Here, the conclusion of the argument.
50.
50.
It will not reach.
Well, I think.
All right. Let me see. Item number 50. If it is not reached by 4:15, please mention.
Correction of the
Please inform the other side and then mention if it is not reached up to 4:15. Correction, please hand over the slip.
Honorable Justice Parthasarathi Sen's determination. A writ petition, the next date before the certificate officer is tomorrow, your lordship. If the matter can be heard.
Tomorrow, lordship will be there. Yes. Inclusions, please come on Monday. Yes.
Lordship's kind leave to mention.
Mentioning Mr.
Extremely
Chatterjee.
urgent manner. It's about a child. I would not have troubled your lordship. It was sent to mediation. Milord, my child.
It's appearing in the list.
It is not. Yesterday, the report has come, Milord, that the mediation has failed. My child suffers from ADHD. He needs counseling. He needs treatment. Kindly takes it up any day, Milord. Report has come yesterday that it has failed. Kindly takes it up.
Hand over the slip. Yes.
Lordship, I would not have mentioned yesterday. Mr. Chaudhary mentioned it, Lordship.
I mean,
Today, tomorrow, and day after, Lordship, 3 days was fixed for the arbitration, Lordship. Lordship will recall Mr. Sobosati Chaudhary mentioned yesterday, Lordship. Today, the date is there, Lordship. We'll try to have an adjournment if it can be taken up tomorrow, Lordship.
All right.
If
Hand over the slip.
Lordship, there is great urgency in this matter. If the order of stay is not passed, then the warrant of arrest will be issued, your lordship. The matter was last heard on 20th July.
The matter is appearing where?
Before Honorable Justice Parthasarathi Sen's determination, it is in item number 288.
Tomorrow the matter is fixed before the certificate officer. Tomorrow his lordship will be there. Yes.
Sir, extension of interim order, mother. Extension of interim order.
Yes, please hand over the slip.
My lord, only appeal, my lord, before a lordship, that is regarding the custody of the child, my lord. Father.
Please, contempt application, new motion. Please mention on Monday. Yes. On the list.
For extension, really reimposition of interim order. My
Yes.
lord, an application. My lord was disposed.
Have you served? You have filed an application.
Yes, my lord.
Have you served upon the other side?
Yes, my lord. Application is.
Who is
filed.
appearing?
This is the affidavit of service. Application is filed, my lord, on the 21st of April 2026. The interim order was last extended on, my lord, the 27th of February 2026 for a period of 3 months, so up to May, my lord. Order impugned, my lord, rejects my application for revocation of clause 12 leave. I am the defendant.
Oh, state is a party.
My lord.
Whom have you served?
Kindly see the affidavit of service. My lord, is served on the government pleader, paragraph 2, my lord. Email ID service, my lord.
May 12.
Yes, my lord. This application is filed on 21st of April 2026, my lord. The interim order was extended last on 27th February 2026 for a period of 3
Please
months.
serve a notice. Please ascertain who has been engaged. I'm making it not today. Because at that point of time, the panel was not prepared.
Yes, that's
I'm making it not today because it has already expired.
Lordship.
Please serve a notice day after tomorrow.
Lordship.
If it is service filed in court today, is Yes.
My lord, the second time service, my lord. Item delivered. My lord,
Item delivered.
yes, yes. Previously, by your lordship's direction, copy served. Then again, my lord Justice Rai directed to serve notice that has also been complied with. My lord, I am for the, my lord, defendant number 1, tenant, petitioner before your lordship
Yes.
for eviction. My lord, kindly see at first, my lord, the plaint, page 13, my lord.
Yes.
Relevant page, my lord, 14. My lord, what is the address? My lord, the
The
address
interim
is,
order is extended till the end of the month. Yes.
I am for the petitioner. My lord, I serve the railway authority. This is the
Because you are appealing for the railway authorities.
somehow I have missed the brief. My lord, today is the desk fees. They are not ready to adjourn this matter. My lord, this is I am one day
Coming after a long
already.
time.
My lord, today this is the last chance, lordship. Today my evidence.
Lordship may fix it on Monday and here,
My
my
lord,
lord,
7 days stay. My lord, 7 days stay.
or day after tomorrow, my lord.
What is the next date fixed?
Today. My evidence, my lord, today is the date fixed. That's why, lordship, yesterday I mentioned lordship has fixed this matter today.
My lord, may call
The
hearing
interim order was still
September, it was September.
then.
My lord, I filed this application not listed. Kindly see.
When have you mentioned this?
But last occasion, my lord, I mentioned before my lord justice, my lord, that was not listed. My lord,
Extension of interim order, once it is mentioned, I have directed those matters to be taken up.
not
At
before your
least
lordship, not before your lordship. I said that.
September, after that you have not
before your
mentioned,
lordship.
not a single time before this date.
My lord justice, I mentioned 2 times, my lord, that was not
Read
listed.
law expired.
My lord,
Have you taken out any application?
yes, lordship. Can one. Long prior, lordship, kindly see.
The
After time to time, the matter
The
was, interim order was extended, my lord,
interim order is still which date?
till the 31st July, my lord. I should be candid with your lordship. It expired on 31st July. Prior to that, I had mentioned the matter, but it didn't appear before your lordship, my lord. And I'm filing
The
my.
interim
May I file my affidavit of service, my lord?
every service filed in court today is taken.
I'm getting.
Yes. None appears for the next.
Lordship, this is an application for expeditious disposal.
Of what?
Lordship, I am applying for the petitioner. I prefer
Expeditious disposal of what?
Lordship for a miscase that has been filed for the violation of injunction order.
Order 13 Rule 2A.
Yes, Lordship. That is pending since 2017, Your Lordship.
This application under Article 227 of the Constitution of India. Yes, what is this matter?
My lord, it pertains to expeditious disposal
Of what?
of a mat suit.
Who are you?
I am the petitioner wife.
Any alimony order has been passed?
My lord, I am not briefed in this matter. I am led by Mr. Navanil Dey. I am praying for a short passover, my lord.
This application under Article 227 of the
Came for the petitioner.
Yes.
Well, the matter is relating to the rejection order of my order 6, rule 17 application, Miller. Well, the order impugned is at page number 39, Miller. Miller, the amendment has been rejected because the learned trial court required the defendant to prove at the amendment stage itself, Miller, that the historical relationship between the suit plots and the non-suit plots which is the adjoining plots, Miller. Kindly see, Miller, the page number 24, Miller, in the WS, Miller.
Yes.
I have filed the, and here also I have mentioned the inference of the non-suit plots, Miller. That it is the short plot, Miller, one decimal, total 4-5 decimal, one decimal is the suit plots, Miller. And then, Miller, kindly see in the bottom portion, এই বিবাদী বেনালিশি 426, 425 ও আংশিক নালিশি দাগে ভূমিতে এক লপ্তে রাখিয়া উহাতে পূর্বাধিকারী ক্রমে পাকা গৃহাদি নির্মাণে বাদী তথা সর্বসাধারণের জ্ঞাতসারে ও বিনা আপত্তিতে 30 বৎসরের ঊর্ধ্বকাল হইতে ঘাসে সত্যবান দখলিকার আছেন। মানে kindly take trouble to come at the next page, Miller.
The suit is for declaration of title and permanent injunction.
Yes. Yes.
With regard to one plot.
Yes, ma'am.
So how this proposed amendment is necessary? That certain plots were amalgamated, makes a big plot. How this proposed amendment is necessary for the purpose of deciding the controversy between the parties? It's only a simplicity of plot, declaration of title and permanent injunction. You have to show that according to you, you are denying the title.
Well, it was the historical amalgamation that was I am preferring, Miller. Kindly see, Miller, the relevance is shown in the WS also and the report of the commissioner also, Miller. Kindly.
How that is relevant? Commissioner is with regard to certain plots adjoining.
Yes.
The suit is simplicity for declaration of title with regard to a particular
Because it
plot.
was the-
Whether other plots have been amalgamated to make a
Because
huge
it was
plot, how that is relevant for the purpose of deciding this?
It was a
Whether you
bigger
have
plot.
title in that plot, a suit plot or not, that's only relevant.
Because it was
Other facts may not be relevant.
plot, Miller, at that time. And then the Bata plot has come. That's why the only 1 decimal has been pleaded in the plaint, Miller.
Yes.
The Bata plot has come after that. There, from that time, Miller, 30-40 years back, we are possessing that land, Miller. And then for the necessary adjudication, Miller, I wanted to, and I also inference in the
The learned advocate appearing for the
Your Honor, I beg to appear on behalf of the petitioner.
And I am for the
petitioner.
Petitioner.
opposite party number 2.
Yes.
So, Lordship, the issue is very small. Your Lordship, the bank has auctioned the property and issued a sales certificate in favor of the auction purchaser. Subsequently, the borrower has challenged such auction. After contested hearing, auction has been set aside. But subsequent to set aside the auction, the sales certificate has been issued, position has been delivered, and the auction purchaser was enjoying the property. In the meantime, after setting aside the auction, the borrower has entered into a OTS, compromise settlement with the bank. On the understanding that the auction, though the auction has been set aside, I am not going to challenge the same. Let the sale proceed be adjusted with my dues, and the residual dues may be under OTS. Bank has sanctioned the same, and the sanction letter, there was a specific clause that you have to withdraw all your complaints against the borrower. You have to issue a no dues certificate, no objection certificate to the society, so that the auction purchaser can get himself as registered. On the basis of that, we have filed an application before the Debt Recovery Tribunal. Since the amount has been settled, no due certificate has been issued, the bank and the borrower has filed an application for withdrawal of the SURFACE application. At that juncture, the auction purchaser has raised an objection that since there was a direction from the tribunal, auction has been set aside and refund of money, let the bank be directed to refund money. We have argued before the tribunal that he is enjoying the property since then. The auction was set aside in favor of the borrower who is not raising any dispute. The only contention of the auction purchaser is that he was afraid of his registration may not be taken by the society because the auction has been set aside. But the borrower has already given an objection to the society, informed to the borrower, I am not informed to the auction purchaser, I am not going to disturb you because I have already settled
So
the
if
money.
the auction has been set aside, what right does the auction purchaser have?
And the most important
yes,
part
yes.
is missing,
Then-
my lord. There was an order of injunction during which this was happening.
If the auction has been set aside,
Yes,
what right does the auction purchaser have to remain in the property?
Yes. This was the question, and on the basis of this question has also arises mind in the mind of the learned tribunal below, both the tribunal below, set aside our prayer for dismissal of surface application until the bank is not refunding the money.
Until
The bank is not refunding the money to the auction.
refund the money to the auction purchaser.
But the fact here, the tribunal has failed to understand, can't they see their application for refund?
Why are you not refunding the money?
Why? The
If the
answer.
auction has been set aside,
The
you
answer.
cannot withhold that money.
This is the answer. The answer is, your lordship, the predicament of the auction purchaser before both the tribunal below, before the DRT as well as before the DRT Kolkata, was that the auction has been set aside, so I may be dispossessed in view of the order of the tribunal.
Has to be dispossessed.
One has to be dispossessed. One. Second predicament, if the
Please pay the money, take the possession.
yes, one.
When can you pay the money?
Let's say me subject to.
Please, when can you pay the money? This is a short issue. Nothing more.
Yeah,
When
that is
can
why-
you pay the
that is
money?
why- That is why, Lord, say I'm not troubling your
She
lordship.
will hand over the possession. You will have to refund the money. When you will refund the money,
Yes.
I will ask her to refund the deliver the possession on that day itself. When? What is the date? Have you taken instructions?
No, but
Please take instructions. Come back.
Yes.
Yes. Are you agreeable to?
My lord, I am
Deliver
unable
the
to enjoy
possession?
the property, my lord. Let them take back, my
Lordship,
lord.
may-
This order was made when there was a subsisting order of injunction. The entire
Lordship, may-
sale was bad, my lord. Not a
Please, are you agreeable to refund the money? Yes or no?
Lordship, my predicament only 1 minute more. Subject to your lordship, what is fallen from your lordship? Because that is why I'm before your lordship. I will
Simple issue.
It's simple, that is
The
why.
auction has been set aside. You have to refund the money.
This is-
Take possession. I will direct her to deliver possession.
yes,
I
ma'am.
can appoint a special officer from here
Yes,
in
yes.
their presence.
Yes, yes.
So when can you refund? That's the ultimate thing. When can you refund the money?
Lordship, 2 more submission. Thereafter, whatever your lordship will that, I'm about.
Two more submissions means you don't want to refund the money.
No,
Got
I
that?
will. I will. But what is my predicaments? Lordship, after handing over physical possession, auction was set aside after a lapse of 2.5 years. For 2.5 years, the auction purchaser was enjoying the property. After setting aside auction, she filed an application after lapse of 2 years with the prayer either to refund, alternative prayer, or I may be allowed to enjoy the property with no objection from the side of the borrower to the society.
She is not interested now. She wants the money. She will deliver. So now the
Now-
matter has become simple. Don't make it complicated. When can you
Simple,
refund the money?
answer- The another fold of submission, my second principle regarding refund. Your lordship, there was a direction to refund the money. We are not saying we will put one again and auction the property, recover the money. The borrower has given a consent. But for 2 years, she was in possession. She was enjoying the possession.
She was not at fault. You have auctioned the property. You have put her in
It
possession.
was a notional hand
Kind-
over. I have never
Then,
enjoyed possession. You
then
are.
the settlement will not
must
be
speak the correct
settlement will
fact.
not be allowed. You fight it. You fight before the.
No, lordship, my submission before the lordship is that subject to law.
So you are now trying to complicate this issue. When are you? She was not at fault. You have auctioned the property. You have
Lordship,
put her into possession.
Her predicament was to registration with the society. Borrower has given a registration. OTS has taken care of her. Kindly see the OTS letter. Taken care of her interest. And the borrower.
She cannot. After the auction has been set aside, how can she remain?
But in favor of the borrower, auction has been set aside.
Yes.
The borrower supposed to take back possession in terms of the order of the tribunal, but the borrower do not want to.
So then the matter is pending before the tribunal now. So make all prayers before the tribunal. Nothing remains to.
Prayer. That prayer has been set aside. That
What
prayer
prayer?
has been turned down.
That prayer has been set aside that you wanted to settle without the auction purchaser.
No, sir,
You have arrived at a settlement without the auction purchaser. That is what you have said.
Yes.
Then
And my lord,
how can that settlement be arrived at
And-
without the auction purchaser?
Auction purchaser interest has been taken care of. She has been duly informed.
Was she a party in the settlement?
She was, because it was a settlement.
I'm asking you a simple
She
question.
was a third party
Was she
to the
third
settlement.
party? She was not a party in the proceedings.
In the proceedings, she was.
Yes. So you can settle amongst yourselves, leaving aside one party.
We settled the amount after taking care of her payment towards the deed.
Sir, one thing, it can be simplified. If you pay her the money, she will deliver the possession.
If such being, Lordship, my second
Otherwise,
submission.
that settlement cannot be entered into between two parties when there are three parties.
Next submission regarding refund. Then if I am unable to satisfy a Lordship regarding merits, let me come to the refund. Lordship, kindly consider this aspect of my submission, Your Lordship. My submission is, Your Lordship, they have paid on money undisputedly. Sale certificate has been issued. They have registered the sale and they are enjoying the property without any interruption, even after setting aside the auction. Now, after a lapse of more than 2.5 years, taking an advantage of this, since the auction has been set aside, but no.
Sir, it seems that you are interested in litigating. Please litigate. This settlement cannot be registered.
I am ready to pay. What is
So when can you pay? That's the simple question. When can you pay? Please give me a date.
There is 12% interest, I suppose, to which fall.
Please pay him 18%. Please pay her 18% interest. You have enjoyed the money. She's getting nothing. So please pay the differential 6% to them.
Lordship, kindly.
Setting aside the auction purchase, the money you are withholding. Sir, it's things that you are trying to complicate this. Otherwise, you fight it before the tribunal. This settlement was rightly not recorded.
Lordship, may I submit?
And if you want to put an end to quietus to all litigations, please come up with a suggestion. When can you refund the money?
Yes, subject to Lordship kind consideration, the interest part may be waived. For 2 years, he was enjoying.
I was not in possession, my lord.
For 2 years.
I have not.
You have also enjoyed the money. You are a bank. You have also enjoyed the money. So you have obtained. Yes, sir. You have not enjoyed the money. Yes. So how much interest you have earned? Please pay that differential amount. You cannot enjoy that amount also.
Certainly.
Yes.
Certainly.
So both ways.
Yes, reciprocate.
So you have earned much more interest than what she has earned.
Lordship, subject to your Lordship kind consideration.
Sir, that is why I told you, if you want to go into that, you will be in trouble.
Yes.
So you have not kept it in your locker.
No, certainly.
Yes.
Certainly, Lord.
So you have earned much more interest than what she had earned.
But, Lordship,
Now, can you come back when you can refund the money?
Lordship,
Or you want to fight it out before the tribunal? I can pass an orders right now on that.
The tribunal has already dismissed. Contempt is pending before the tribunal. So
Fight it out there. Contempt.
with subject to your Lordship kind consideration, without unnecessarily wasting your Lordship's time, let me take instructions to that effect.
Tomorrow. After some argument, the learned advocate appearing for the
Can the interest part may be considered should be a public money?
Sir, that will be considered, has to be both sides.
Yes.
Please give her the benefit, what you have earned on that amount. Then she will get much more better.
I have not got possession, my lord. This sale was during an injunction order, subsisting injunction, illegal sale.
They are enjoying.
Now I think they will revert back with better instructions, I suppose. Yes.
Lord, I am for the tentative decree holder.
Yes, what do you want?
Petitioner before your Lordship, Lord. I am praying expeditious disposal of title execution.
Expeditious disposal of title execution case.
6 of 2024.
How many miscases are pending?
Lord, only one.
Only one. Under what provision?
Lord, suit decreed. Thereafter,
Miscase. Under what provision miscase is pending?
Lord, title execution case.
Sir, I have followed it's a title execution. So, in title execution, there are several miscases which are pending. That is what I am asking you. How many miscases are pending? No miscase.
No miscase. Waiting for the order of stay.
Stay of?
Stay of the first appellate court. Lord,
Oh, appeal is pending.
Appeal is pending. Lord, 2 years waiting for stay.
This application under Article Yes.
My lord, at the instance of petitioner, a money suit was filed on February 2024. But after lapse of 2.5 years, it is still lying in the stage of acceptance of WS written statement.
This application under Article 227 of the key. From the order happened. This court finds the 2nd of September is fixed for.
For the plaintiff petitioner, these against the refusal of temporary by both the trial court and the appellate court. Suit between Lord sister and brother. Plaintiff is the sister. Defendant is the brother.
Plaintiff is the sister, defendant is the brother. Partition suit.
No, not a partition suit. Milord, dispute regarding the mother's maternal property, mother's house, which Milord, the brother got a gift of the entire house in his favor. Challenging that gift deed.
Brother means the defendant.
Defendant.
You are the plaintiff.
I'm the plaintiff. My plain case is that throughout mother was staying with me, brother was not taking care. For a limited period, she went to that house. During that period, brother has procured this gift deed. She was not in a mental state to execute that deed. Deed was of 17, but I came to know in 2023 when he started demolishing the building. So knowledge is 2023, April 23. This was my case. Trial court rejected in the suit. Initially, there was prayer for declaration.
Suit filed by you or the mother?
By me. Mother expired. By me.
Where is the plaint?
Plaint is at page 15. Now, this is the amended plaint. Initially, there was no prayer for injunction, only prayer for declaration was there. Page 15. Trial court rejected by saying that there is no prayer for injunction. So you will not get any temporary injunction because it is in aid of the final release. On that note, I say that
15 is the amended plaint.
15 is the amended plaint. Before that,
how this suit is maintainable, Mr. Banerjee? How this suit is maintainable?
Sir, brother is demolishing. I'm challenging the gift.
I'm asking you how the suit is maintainable. Then the question of injunction comes.
Challenging the gift deed, my lord.
Yes. Then
after declaration that the gift deed has been obtained fraudulently.
You are out of possession.
Now, I am not co-sharer. I am saying that I have married.
Now you cannot claim as a co-sharer. You cannot claim as a co-sharer unless
the registered instrument. But my case is not declaration. Not
you do not have any possession, Mr. Banerjee. If you do not have any possession, without any prayer for recovery of possession, this suit is barred under section 34.
This the plaint can be. There's a
scope. First amend, make the suit a maintainable. On the face of it, it's not a maintainable suit. Here and now, the plaint can be rejected, Mr. Banerjee, at any stage. Suo motu, it can be rejected. So you are taking that risk.
No, your lordship can also allow me the plaintiff to rectify because it's a prayer.
Rectify, that's a procedure. So once you rectify,
consider about constructive possession.
Mr. Banerjee, there is a gift deed.
Nobody's
if it is a registered deed, Mr. Banerjee, unless and until that is set aside, there's a presumption as to the
presumption is that
if there's a presumption.
There are the court comes to the finding, appellate court, that there are tribal issues. It has to be decided. at the time of trial whether the deed is valid or not. Now, on the basis of that pilot finding, although he finds that there's tribal issues, refuses on the ground that there is a registered instrument and that there is no prayer for recovery of possession.
Oh, that's the finding, rightly.
Appeal court.
Then, Mr. Banerjee,
This can be always.
that was
rectified.
my observation also. If it tallies, I cannot say it's wrong.
Appeal court has not given true ground.
At least I cannot say it's wrong.
But not kindly consider, my lord, there has to be not an ouster. If I'm a co-share, I'm a sister. Now, mother's house.
Now
there,
you are not a co-sharer, Mr. Banerjee.
Question of
Please get the deed set aside, then he will be a co-sharer, then he will be filing a suit for partition. Until now, unless that is set aside, how can you claim to be a co-sharer, Mr. Banerjee? This is a registered instrument, he is the sole and absolute owner.
Presumption is that not.
Then
there is an instrument.
Then you cannot claim to be a co-sharer now, unless that is set aside.
But it is nobody's case that I was ousted from the property. Even in the written statement.
Possession, Mr. Banerjee. Give deed, this shows, and recovery of possession. If you are in possession of the property, Mr. Banerjee, no one can demolish that. Cannot be. And if you are in possession, mother would be also with you, so you must be knowing what happened to the property. Demolition cannot be done in one. They will come, ask you to throw out, to get out of the property. This shows you are not in physical possession.
I submit this, my lord. Would your lordship not kindly give me liberty, my lord, to file appropriate applications, my lord? If file, my lord, I shall file within, I undertake to file within, my lord, 7 days. Let those be considered, because otherwise, my lord, after amendment, if your lordship knows not, then in this process, if third party, my predicament is not, if not he develops and sells the property, multiplicity of proceeding, my lord, my right.
The only difficulty is, Mr. Banerjee, now this is not maintainable on the face of it. No injunction can be granted.
Kindly request my undertaking that I'll file the appropriate applications, my lord. Let those be considered expeditiously, my lord. Let the applications be considered. I'll file amendment and an injunction, my lord. I'll move after that. Otherwise, not alienation would, my lord, defeat my purpose.
This application under Article 227
Praying for release.
Since I'm not inclined to
These suits arises out of a suit for partition. Milord over the water body and Milord also the food part. The record of right Milord specifically said so. But Milord the defendants Milord opposite parties Milord started construction thereon. Milord to that Milord we filed an injunction petition along with Milord that Milord suit for partition. But Milord that has been refused. Milord we have gone before the learned Milord additional district judge. Milord that order has been affirmed. Against which Milord we come. If your lordship kindly consider first Milord the paragraph the annexure.
Where is your application for injunction?
Your lordship kindly consider page 15.
Where is the order of the trial judge?
Trial judge order Milord lordship kindly consider after Milord page 16. Milord lordship kindly consider page 16 once. Milord the water body is being filled up in this way. Milord wherein Milord we have Milord 1/3 share. Now Milord learned trial judge order Milord will appear from page 18. Lordship kindly consider. Though Milord it has been stated that the plaintiff has claimed that the defendant number 1, 2, 3 have started raising construction within the water body.
Where is your application for injunction? Where is the written objection?
Written objection or written objection?
It was a contested hearing.
Yes.
Yes. Where is the written objection? You have your house there.
No, it is a Milord, it is a water body and Milord a pukur part. Milord, I have no house. Milord, they have started construction there. We filed that Milord, thereafter Milord filed the suit for partition. And Milord, there Milord, it has been hold Milord relying upon the judgment Milord or court Milord WLR Milord 2016 4. Milord 122. On the basis of that. Milord, can you consider that?
They have purchased this.
Some portion of the land from other co-sharer without any partition. My lord, I am the owner of 1/3. My lord, total land is, my lord, 16 decimal. Pukur part, along with, my lord, water body. And my lord, there they have started construction after purchasing.
Do you have the copy of the plaint?
Lord,
Why you have sought for partition with regard to Schedule 2 property?
because, my lord, they have
If it is an undivided, both properties, so the suit is bad for partial partition.
but my lord, lordship kindly consider.
What but? If you have not, you have not incorporated the prayer for partition with regard to the entire property. Is the suit for partition maintainable?
Kindly consider.
Sir, you cannot. This shows that he has an exclusive right with regard to Schedule 2 property. That is why you are leaving Schedule 1 and is bouncing on Schedule 2. Suit is bad for partial partition.
Schedule 1, my lord,
Schedule 1, you also, if you claim it's an undivided, so all three brothers has 1/3. He has purchased from one of the co-sharers. So you will also be having 1/3 in Schedule 1, 1/3 in Schedule 2. And you are claiming partition only in regard to Schedule 2, not in regard to Schedule 1.
Schedule 1.
And he says he has absolute ownership with regard to Schedule 2.
But my lord,
Either your suit is bad for partial partition, on that you are not entitled to injunction.
but if
Now
your
what you want to do?
my lord, if your lordship kindly consider, my lord, my lord,
It's better if you go with this suggestion, you have to amend your plaint. Otherwise, it's difficult.
Right. I
That is why I wanted the plaint, because something I got from the injunction and the written objection. This is really to put pressure upon one of the co-sharers.
Then lordship kindly give liberty to file fresh suit, my lord. I think.
Fresh, whatever you want, you can do.
My lord, lordship.
Whatever you want, you can do. But injunction, nothing. By the order impugned, Yes.
Lord, 15, my lord.
Surface.
Surface against the order of the DRAT. Appeal dismissed.
You have become specialist in surface, Mr. Wardon. No.
This is the section 17 application with annexures, my lord. The annexures has
Yes, what is this? What is this order?
This is an order dismissing my appeal by the DRT.
Appeal under?
Section 18 of the Surface Act.
Against?
Section 17 filed by me, dismissed by the DRT. DRAT affirms the order, dismisses my appeal. I am before my lord.
What remains?
No, anything.
Section 40 position taken.
No, I am in possession.
Section 14 not invoked.
I am in possession, that is squarely admitted by them in their opposition in before the appellate court. Page 179, volume 2.
What is your ground of challenge?
13 to notice does not indicate the date of NPA. Number 1. 13 to notice does not provide the details of the outstanding. But this is the question, my lord, on the issue. I would invite my lord to decide whether the date of NPA has to be mentioned in the 13 to notice or not. It says 13 to details of amount outstanding and my lord, the schedule of the property sought to be enforced. It does not say date of NPA should be mentioned. Does not say, my lord. Now, my lord, kindly visualizes this. I'll come to the facts later. My lord, this is a point of law. I'll address my lord on the point of law, my lord. Now, my lord, I have a right of representation against a 13 to notice under 13.3. 13.3 I have. So, my lord, at that relevant point of time, what could be my objections? My objections could be limited.
13.3 you have complied.
Yes, you have complied.
Then?
No. So, my lord, at a 13.3 stage, what can my representation or my communication contain? It has to contain that this account has not been classified.
So one is 13.2 does not give the date of NPA.
And my lord, does not create the bifurcation
of
the details. My lord, a total sum of amount has been claimed. There has to be a bifurcation into principal and interest. Now the learned lower appellate court.
What does it say? Under what provision?
13.3.
13.3.
Yes. And my lord, this has been
details of the amount payable by the borrower.
Yes, details of the amount, not the amount. There's the difference, is the details. And this point had been, my lord, considered by your lordship's court in 2010, which says details must mean principal and interest separately. Also considered by a division bench of the Gujarat High Court, Punjab High Court, has been held that details mean you have to say the principal as well as the interest. Because I'll tell you the reason why, my lord. Because, my lord, at the 13.2 stage, after I get a 13.2 notice, what the 13.2 notice?
What is the finding and what are the other points?
My lord, there are 3 or 4 other points, my lord. Kindly seize, my lord, kindly seize.
What is your best point, Mr. Bordon?
13.2, no bifurcation, no date of NPA.
All right. Let me see how the appellate tribunal has dealt with that.
Yes, my lord, kindly seize.
So these are your best points.
Yes.
So let me see what is the finding on best points.
But, my lord, kindly, my lord, take the 13 notice for once. 13 to notice for once.
I will go to that.
Yes.
Please show me this.
My lord, this would be.
Which paragraph?
This would be, my lord, paragraph.
Page, the certified copy.
Yes, paragraph 14. Page 6, running 6.
What is the date of the order?
Date of order is 1st of July 2026.
Yes, I've got.
Kindly see. Paragraph 14. Perusal of the notice under section 13.2 dated 6/5/10 would reveal that the demanded dues as on 31/12/10 was rupees such and such. Since this was an overdraft facility, the bifurcation of the amount sanctioned as interest was not required as interest amount would be added in the principal as soon as the same became due. Unheard of. Unheard of. According, we do not find an illegality in impugn notice under section 13.2. Sees Mullet. Now Mullet kindly takes a 13 notice for once. It says details are there, Mullet. I'll show the 13th notice.
The tribunal's finding is also same.
Tribunal doesn't go into that.
Did you raise that point before the tribunal?
Yes. Yes.
Show me order of the tribunal.
I'll just show. Kindly takes a 13 notice for once, 13 to notice for once.
Page.
That would be Mullet, page 44 of the essay application I handed over, Mullet. Mullet, so the law appellate court says principal and interest would be subsumed into that total figure. Kindly sees. Page 44. We wish to inform you. Got it, Mullet? We wish to inform you. Just next to or. Send trade OD Mullet to then or.
Yes.
We inform you that out of the total amount of such and such, you have defaulted in repayment of entire amount of rupees such and such. Kindly seize the bracket, which represents the principal plus interest. So Mullah, the 13.2 says it's principal and interest. DRT says it cannot be. And well, that is the way it is, 13.2. That's my first point. Mullah,
where is the statement of accounts?
Kindly sees. Now sees. Mullah, now kindly takes my representation at page 46.
Of this bunch.
This bunch. And precisely at 47.
Yes.
Paragraph 6. I mentioned that my recent letter has been received by such and such. I further state and submit that despite my several requests, you did not submit to me any account statement with the details of transactions. So, those details.
Now, Mr. Bordon, everything is available online.
No, these are not available online. Once your account is declared as an NPA, you cannot download it.
No, previous to that NPA.
I don't have it.
Why? Previous to NPA, why will not be having that?
May I put it this way? The statute mandates that the details have to be provided. So, Mano, that is statutory interdict.
No, before the NPA, please show me the accounts.
I don't have the accounts prior to NPA, Mano. This was not for the court below, not filed here as well. But Mano, the statutory interdict is, Mano, details have to be provided by them. And Mano, in my 13.2 representation, I say details have not been provided. Now, Mano, see how they deal with it in their reply. Kindly see, this would be Mano, page 50.
Yes.
Kindly see, not a whisper. They should provide me, my lord, with the details of the outstanding. Not a whisper that has been provided too earlier, or we will not provide it. So, Munda, this is the evasive reply to a 13.3a. Letter undelivered. So may I put it this way, my lord, when I have given them a representation, they could have jolly well, my lord, annexed the statement, which they do not and they will not. And my lord, the DRT says, since it's an OD account, my lord, principal and interest, the interest automatically becomes the principal. If that be so, my lord, then this 13.2 notice, which appears, which I showed, my lord, at page 44, says this amount represents principal plus interest. So it says principal plus interest. Is the duty of the bank to provide me what is the principal, what is the interest?
Already you serve upon the bank.
We'll serve till that time, let them not take possession. But
Both-
they will,
both.
they will, Mullah.
Let them, they have not yet initiated section 14.
Mullah, they have,
Uh,
kindly takes the pleading at page 179, kindly takes it for once.
Yes, yes.
They say it is pertinent to mention the bank could not put the purchaser in possession since the appellant refused to hand over possession. So, so there, once this order has been passed, they'll take possession.
Let them take possession.
Or in that even, Mullah, kindly keeps it on a shorter date, Mullah, as a and with as a specially fixed matter. Mullah.
The
Has not been taken by them. Kindly one line.
It's already there. Don't complicate. If it is in the order, they will take possession.
Then one indulgence, my lord. If I may take it, my lord. On Friday, a matter was listed before my lord. My lord, I could not appear because of
What happened?
My uncle passed away, my mama who was.
No, but what happened?
My lord, that has been made out of list, my lord. The client is suffering, my lord. A very urgent matter, my lord. I wouldn't
Please
have
mention maybe. Yes.
mentioned it yesterday, my lord.
Yes.
I'm the petitioner defendant of the trial. This impugn order not arises out of a testamentary suit wherein I am the defendant. Then in course of trial, the matter is fixed for page board. I have taken out an application for comparison of a documents from the original one.
Comparison of a document with the
Because
original.
my objection is based on genuineness and the forgery of the signature.
Of what?
Testator, of the
So
testator.
you want comparison of the signature?
Comparison of the signature with the admitted documents being executed by the testator in during his lifetime. That was negated by the trial court below.
Who are you?
I am the brother of the testator, and the executor is the son of our sister. He is alleging that the will has been executed by the testator in favor of appointing him as executor. Wherein I have entered in and put my objection.
Please give me a minute.
My lord.
Defendant number 2. How many defendants are there?
Two defendants are there. There is, so far as my instruction is concerned, the sister is another dependent who is also the executing.
But you have not implemented the other sister. There are only two parties, one petitioner, one opposite party.
Pronoti not implemented. Pronoti not implemented here before your lordship.
Yes, it's not at that stage preserving your right to apply at the later stage. What's the difficulty? Evidence has not yet, sir, evidence has not yet started. So if the will is not proved by the attesting witnesses, everything goes.
Kindly appreciate. My objection is based on
all right, it will be considered. It has not been rejected.
As
please consider the will has the execution of the will has to be proved by the evidence of the attesting witnesses. Now the attesting witnesses comes and denies the execution of the will.
No, attesting witness.
So the evidence has not yet started. So let the evidence start. You can cross-examine. You'll be having your right. That has been preserved. What's the difficulty?
May I, if subject to lordship, kind sanction. Defendant number 2, this is another sister. She is one of the attesting witness. She is admitting the will. So the signature. So and the testamentary suit, the genesis of the suit is will. So will come on board. And at the very outset, I have raised this objection because my
will has been marked as an exhibit.
Not yet, my lord. Not
So if
as
the will has not been marked as an exhibit, how can it be sent for comparison?
it is on, my lord,
So that
peremptory
is why it's the best option. It has been kept. You have been your right has been preserved at the later stage.
My lord, I have seen, since it is premature, so it has been. So, my lord,
Let the evidence start.
my lord,
After
my
that,
lord, my submission would be in that case, my lord, if
sir, at this stage, it cannot be sent unless it has been brought in evidence.
my lord, the crux of the proceeding, my lord,
Sir,
is
you
the
are
will.
not appreciating.
My lord,
Unless that document is not proved, that is not brought into evidence, how can it be sent to the handwriting expert? And the other documents for with which it has to be compared, those signatures, either it has to be admitted or proved. So where it will come, it has to be in the evidence.
my lord,
So how can it be sent to now the disputed signature has to be compared with some admitted or proved to have been admitted. So these things cannot happen prior to the evidence. How can it be sent?
It seems, my lord, all the documents are before the trial court below, my lord. So
Then it can be sent. That's the procedure, sir. Not understanding the procedure, what can be done. Ashun, by the this application under Article 227 of the Constitution of India is at the where is the other party? Why have we left out one?
here, not implemented here.
Why?
I don't know, my lord, it has been drafted.
You are the advocate. How can you say that I do not know?
My lord, leave be granted, my lord, to amend, my lord. Leave be granted, my lord.
On the prayer of the learned advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to amend the cost title by adding None appears for the petitioner at the time of call. No accommodation has been sought for either. In view thereof, CO number such and such stands dismissed for default. Yes, next.
Lord, 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 this present revisional application has been filed. It pertains to interim visitation of a minor child, my lord. The petitioner is the father. He is also the non-custodial parent.
That has been rejected.
My lord, has been given, which is totally contrary to the guidelines, which is formulated by this honorable court, my lord, have been given just one day in an entire month, which is third Saturday, for a limited period of 2 hours, that too in court premises, my lord, which is totally contrary to the guidelines, 2025 guidelines, my lord.
What happened on 16th of February 2026?
16th of February 2026, my lord, nothing happened. The court is vacant. The matter is not.
So you were
taken up
directed
thereafter,
to file, the parties were directed to file their respective affidavits in terms of that 2025 guidelines.
My lord, if my lord sees my application under section 12 for interim visitation has been disposed of, my lord, the 2025 guidelines is cleared about the interim
For that, you
visitation,
have
my
been
lord.
given leave to file affidavits. The court will consider that.
If my lord sees the guidelines, we have placed the guidelines while this order was passed.
For
my lord.
that, the affidavit was
My
directed
lord,
to be
no
called
court
for
is
by the
there.
respective parties.
My lord, the no court is there. My lord, this order which has been passed is totally contrary to the guidelines. If my lord takes up the guidelines once.
No court is there.
My lord, no court is there.
Are you sure?
My lord, my lord.
Where? Court is not there from when?
My lord, after this order was passed, the matter was not taken up.
That's different thing. You are saying the court is not available.
The court is vacant, my lord.
Since when?
As I'm instructed, the court is vacant after the matter was taken up since January, my lord.
What are the subsequent orders?
Lord, if my lord takes up subsequent.
What are the subsequent orders?
Hello.
What happened on 16th of February 2026?
The matter was not taken up. The court is vacant, my lord. The
Sir,
dates
charge
are
court
posted,
will be
my lord.
there.
My lord, the charge court is not taking up the matters as I am instructed, my lord.
Date will be fixed.
The dates
Where is
are
the order
fixed, my
sheet?
lord. The order sheet is not there, my lord. Kindly grants me a day's time, my lord. I'll come back with the order sheet, my lord. My lord, otherwise, if my lord grants me liberty to place the guidelines for once, my lord.
Yes.
Shall I put it down? My lord,
Yes.
my lord, if my lord, দুটো আলাদা আলাদা পার্টে কেন? My lord, this is chapter 1 of the guideline. I believe the entire guideline was not there. আলাদা আলাদা পার্টে দেওয়া আছে কেন?
Chapter 1, yes.
The chapter 1 of the guidelines. My lord, part B. My lord, herein the age of the
Part B, yes.
My lord, the age of the minor is 8 years. Is going to be 8 on 23rd of August, my lord, this month. My lord, part B is applicable in as much as the children is 36 months and older. My lord, it says the weekend, the non-custodial parent, the father, the petitioner being the father is a non-custodial parent, and the distance between the custodial parent's house and the non-custodial parent's house is hardly 500 meters, my lord. It says.
So these are factual part. How can that be decided in a revisional application? That is why the court directed both the parties to file affidavits. Can it be decided in a civil revision application? These are all factual aspects, and first paragraph, paragraph 4 may decide taking into account the relevant factors. All these factors are to be taken note of on the basis of the affidavits filed. Thereafter, the judge has to take a call.
My lord, if my lord, that is for the final adjudication, my lord. If my lord, in my understanding, my lord, if my lord takes up chapter 1, it says about the interim visitation while disposing of the application under section.
Sir,
12.
entire thing is interim. B is also interim. For the purpose of interim, sir, there are several factors which are to be taken note of. You cannot take one, skip others. All these factors are to be taken. For that, affidavits have been called for, and we will not be filing the affidavits.
My lord, in that event, my lord, kindly pleases to direct the court below to decide this issue with
Has only the
within a
date was
limited
fixed.
period
Have you
of time.
filed your affidavits?
My lord, that I need to.
You have
my
wasted
lord,
6 months of time.
My lord,
Today we are on August. On 16th of February, we are directed to file.
My lord, we have, like, my lord, I
You
don't
have
have
filed.
instruction, my lord. I'm taking, kind of grants me a minute's time, my lord. My lord, not only that, my lord, if my lord takes up the third last paragraph of the order,
yes,
a visitation right is given in court premises, that too for a limited period of 2 hours. My lord, the distance between both the parents' houses.
What is the age of the child?
My lord, 8 years. My lord, he is
8
getting-
years.
My lord,
When have you last met with the child?
my lord,
When are you being separated from the child?
my lord, every year I am getting a visit in the court premises, my lord. I have been separated for last 2 years.
Last 2 years.
My lord, not
When have you last met with the child?
lord, in the last month, my lord, in the court premises, and the what problem I am facing, because this entire visitation is taking place in presence of police officers. There are several police officer advocates, and the child is getting terrified in that court premises. My lord, the learned court below has arbitrarily fixed the place for visitation in the court premises. If my lord takes up the guideline once, if both the parties do not come to an agreement regarding the place, then only such a direction can be passed.
Are you agreeable? Both the parties agreeable.
My lord,
What was the agreed place? Please show me.
My lord, that was not agreed. That the
Then what
parties did
can
not
be
call
done?
for, my lord. The order, the
So
learned
what
court
can be
below.
done if both the parties do not agree? You will suggest place X. Other side will suggest place Y.
My lord, that was not called for. Why?
Even if the place Y is more suitable, you will not agree to place Y.
My lord, why?
That's the ego between the parties.
My lord, because of which the child is suffering, my lord.
Only for your ego. Only for ego of both the parents.
My lord, the
For
distance.
that the child is suffering.
My lord, the distance between the houses of both the custodial and the non-custodial parents is hardly 500 meters. It's less than 10
You
minutes.
will go and visit to your wife's place. Wife's place.
Or to some park nearby her house. But what the
You know,
court has.
park is a very good congenial atmosphere nowadays.
My lord, there are
For a
children's
child.
There, I am told there are children's park near her place.
You are sure that's congenial?
My lord,
Nowadays.
My lord, in that event, a special officer may be appointed to take care of that. But my lord, the child is getting afraid while visiting the court premises every time, because this
So
visitation.
two things can be done. One, please ascertain whether the affidavits have been filed, so I can direct the court to.
My lord, the affidavit is ready since January.
But you have
just
not
because
filed
the-
since you have challenged
Just
this.
no, we have challenged it now. No, the charge court is not taking up the matters. The court is
What's the
lying vacant.
difficulty in filing?
My lord, the court is lying vacant. The matter is not being taken up. If my lord directs the charge court to take up the matter and dispose of the matter,
That's the difficulty. Taking up is a secondary thing. First, filing. Can you file and come back? You have not yet filed.
my lord, it's ready, my lord. We have made it
Ready
my
is
lord,
one
since
thing.
January, my lord.
You have not taken any steps to file it.
Because the matter is not being taken up. If my lord
That is
directs
what
the
you
charge-
have. That is why you have not filed. That is why you have not filed.
It's lying vacant. That's why we could not file it, my lord. The matter was not taken up.
Which court? Hooghly. The learned advocate appeared
my lord, birthday. He's going to turn 8 on that day, my lord.
List this matter on that has been not pressed.
Not pressed. And there is no endorsement in the application also.
File an application for recalling there. What can be done here?
But thereafter, my lord, several times I have mentioned the matter for taking up the matters. My 39-4 is also pending. 711 has been disappeared from the board.
711, I can request if it is pending to take up. But if it has been not pressed, you have to take appropriate steps there.
I will, my lord, and the
This
39
application under Article 227
and
of
39-4, my lord, kindly.
39-4.
That is also, that is pending.
I think there is nothing much in Order 711.
No, there
Only to take time to file the
no,
written
there
statement.
is material, my lord. There is material. The suit is not
Take
even
time to file the written statement. You could not prepare the written statement for that Order 711. This application under Article 227 of the Constitution of India. Rule 70, 711, nothing
to
will
file an
remain.
afresh, Lord.
Because what you have taken in Order 7, Rule 11, they have tried to cure it in Order 6, Rule 70. So, and by procedure, that is to be taken up first, then Order 7, Rule 11, you will not press it. Otherwise, will be dismissed for non-prosecution. Either way, this way or that way.
As you wish.
Yes. 20, yes.
Your Lordship, my lord, I'm for the petitioner. My lord, the senior citizen, 91-year-old petitioner before your lordship had filed proceedings for succession certificate, my lord, before the learned district delegate at Barrackpur in the year of 2023, my lord. And your lordship is well aware, my lord, it is only 6 months time period, my lord. However,
7th of September is for orders of what?
my lord, kindly peruses the last penultimate page of my application, my lord. The orders are there. For the last three occasions, my lord, 13/1/2026, 27/2/2026, and 11/6/2026, my lord. All of them, they are like mechanical orders, my lord, fixing for final pronouncement of the judgment, yet it never comes, my lord.
This application under, this is a probate proceeding.
A succession certificate, my lord.
Succession certificate, this application under Article 220.
I'm appearing for the petition. This case arises out of a preemption execution case where
Preemption execution.
yes, madam.
Yes.
I have challenged the order under Rule 208 of the CRO, my lord.
208 you have challenged.
208.
Why?
Well, the two grounds of challenge, my lord. I'll be very brief. One is the appeal from the preemption misappeal is pending before this honorable court.
Appeal pending before this honorable court?
Revision, my lord. Revision.
Revision.
Civil revision application in the nature of the appeal. And my lord, second ground is the 208.
Is there any stay?
No, my lord, there is no stay. It was taken
Let
up
the
once,
execution proceed. If you get an order,
my lord,
have your remedies otherwise.
well, that is the difficulty, my lord. I will be remediless because, my lord.
Why?
Yes, my lord. Because 208 was resorted to without having recourse to Order 21 Rule 97. I'll have no relief under Order 21 Rule 100, my lord. That is my difficulty.
Sir, how can you have? How can you have 101?
Preemption case, my lord. I am not a.
Sir, you are a judgment debtor.
Yes, my lord. I am a judgment.
So what right, title, and interest will be adjudicated under Rule 101? What right, title, and interest will be adjudicated again?
No, my lord, not that.
Then
the preemption appeal is.
So you do not have any right. So
preemption appeal is pending.
All right, 208 I am setting aside when he will deliver possession. 208 not necessary. Police will not go.
Well,
police will not go. I am appointing Mr. Mukherjee as a receiver.
I'll take instruction.
He will deliver possession.
Well, I'll take instruction.
Police will not go. Don't invite the police in such a case.
I'm not inviting the police, my lord. Even they.
You have some respect in the locality. Police will go and throw you out.
That is the
Please don't invite that.
That is one of the most.
Yes, that is what I'm telling you. Please don't invite that. Don't go to that extent. Don't resist. Please vacate honorably and let the possession be taken by the decree holder. That's the best option.
My lord kindly keeps it
What's the issue in the preemption revision? Nothing. The facial expression shows nothing.
Appeal was dismissed on the
So it
grounds
has
of
been
delay.
kept as Kubichana there. Is that a fact?
On the first day, my lord, the trial court judgment was not there when it appeared before Honorable Justice Basu at that time. My lord. The trial court judgment certified copy was not there. Appeal court judgment certified copy was there. That is why it was adjourned.
What is the issue involved in the preemption?
My lord, the appeal was dismissed on the ground of delay.
Ground of delay means?
Delay in filing the appeal, my lord.
Delay in filing the appeal. How much delay? In days, months, years?
Well, the judgment in the preemption before the trial court, it was passed ex parte. The judgment debtor did not participate later on after filing written objection. My lord, there was a delay, my lord. May I just
In
check?
days, months, years? Which?
I'll just check, my lord.
Civil division filed when?
2024, my lord. It is not running in the list at the moment. After it was there in the
Don't take chance to run it in the list. Let it remain
No,
where it is there. In the meantime, let the civil division application
the
be
record, my lord.
disposed of. Then you might get an interest in mentioning that matter.
Of the record matter, my lord, my interests are also be seen for that appeal matter. My interests have to be seen as well.
Your interest?
Instructions.
Ashun, this application under Article
Lord, I appear for the petitioner. This is an application for expeditious disposal, my lord.
Of what?
Of the visitation rights application, interim application in connection with
This
the
application under Article 220.
I'm appearing on behalf of the caveator, my lord.
Yes, what is
The
this?
Defendant number 5 and 6 in the application under section 6 of the specific relief act is the petitioner before your lordship. But if your lordship takes up, my lord, the application under section
It's an appeal, Mr. Mukherjee.
really an appeal. Lord, I should not say by bona fide mistake because of the conduct of the learned trial judge in dealing with the matter. Lord, my client initially preferred a title appeal. That I must show before your lordship. Because the learned judge really, though the application caption under section 6, but when the rival dispute with regard to title, different deeds have come up before the learned trial judge, the learned trial judge swayed away, not treating the suit to be a suit for declaration of title. And indeed, the learned trial judge declared the title of the plaintiff in a form that plaintiff have right title interest over the suit property and thereafter recovery of possession. So, decree has been drawn up. And my client preferred a title appeal. Subsequently, with better advice, it is found that it's not maintainable since the suit, the gamut of the suit, is under section 6. No prayer with regard to declaration of right title interest even being prayed for. But indeed, the learned trial judge has done the exercise and passed a decree. Thereafter, the appeal was withdrawn and the present revisional application is before your lordship. The three prerequisite under section 6, he has to show he was in possession. He has to show that he has been illegally absent.
in my respect to submission, the initial bar is not to go into the dispute with regard to title. That's why subsection 4.
No,
May I-
Mr. Mukherjee, that may be a bar, but the question is there any finding with regard to dispossession?
No, I shall not also place that. That's why the three prerequisite is, my lord, he was in possession, he has been dispossessed, and the plaintiff has come up before the court within 6 months from the date of dispossession. These are the three limbs which the learned judge has to go into. It is a vacant land, my lord. Now, if your lordship takes up the judgment, it's entirety of the title that has been gone into. by
Where are the
learned
issues?
judge.
Where are the issues?
Yes, my lord. If your lordship takes up, my lord. Kindly takes up, my lord, internal page 5 of the order impugned before your
Where
lordship.
issue number 4 has been discussed? Where issue number 4 has been discussed, please show me.
Yes, my lord. My lord, here, my lord, the issues have not been, my lord, dealt with, my lord. It has been dealt with, my lord. May I take your lordship? Issue number 4 is at five six তো এটা একটা illegible না issue number 3 has been dealt with in page 11. And thereafter issue number 2 and 5 6.
Yes, there's a finding that he was in possession within 6 months preceding the date of filing of the suit.
That's finding is contrary to the record. Why? But yes, but I cannot answer in both ways itself, even on merits of the matter. Today, admitted position is that my predecessor's name, it's a vacant land. My predecessor's name are being recorded.
Yes. What do you say?
And
I am purchasing the land.
Now this
from
is to be hard.
cooperative.
This is to be hard. So I'm fixing her this for hearing. Because it's just like an appeal. Because here the appeal does not lie. So revision is
Does
just
not
like
lie.
all the evidences or other things are to be taken, are to be considered.
হ্যাঁ, just like হ্যাঁ, তো অ্যাপিলের মতো হিয়ারিং হবে তো।
I was protected before the even appellate court by an order of stay.
Where is
Because-
that?
Yes, but page 145 of my lord's brief.
145.
Interim stay.
Yes, yes. Thereafter, I withdrew my appeal since it's not maintained.
Yes, 145.
Page 145 is the stay order, my lord, which
Kindly look into the just ordering portion of this judgment. Kindly look into.
Yes. Yes, ordering portion of the judgment.
Survey Commission's report is a part of a degree.
Yes, I will consider that. I will
Yes.
consider that at the time of hearing.
The Survey Commission report is not is annexed herewith.
I have
So,
annexed, my lord, I have annexed, my lord, my mutation certificate, my predecessor's mutation certificate, my obtaining of sanction.
What is with regard to occupation charges, Mr. Mukherjee?
Here, my lord, the
Petition for recovery of possession has been passed. Not a question of title.
that has been exactly precisely decided by the learned judge.
That is the different. If you can eschew, even if we eschew that part, that the findings on title, you can that can be eschewed. That the finding on title cannot be a thing which can be decided.
That's why, my lord, it's a patent illegal exercise of jurisdiction.
That's
Kindly
one part.
consider that.
That's one part. But recovery of possession has been directed against you. So if you are,
Lord, I appreciate, my lord, what is, my lord,
then you have to.
I was, my lord, in this peculiar facts and circumstances, I was enjoying an order, my lord, before the, my lord, even first miscellaneous, sorry, my lord, first appellate court, my lord, unconditionally. My lord, your lordship can.
That's a different thing altogether.
Your lordship can, or today itself, I am ready to move the matter, my lord, and to finish it off. It's not that, my lord, because the hardship will be, my lord, it's my
Evidence and other things will have to be gone into.
I can show.
Mr. Mukherjee, if it was a first appeal,
Just give me 2 minutes, my lord. I can demonstrate before your lordship that the plot number that has been mentioned in the plaint as well as in the schedule of the plaint that has not been tallied with the deed. The deed is itself behest of any RS plot number. When that has been pointed out before the learned judge,
you have a very good case.
they comes and try to, my lord,
Please
adduce
think of a first appeal. Please think of a second appeal. Admission on substantial questions of law. Are you not liable to pay occupation charges? That's admitted on a substantial question of law.
I say, my lord, it's
Mr. Mukherjee, if you are enjoying, you may not pay, but you have to deposit.
But it's a vacant land. It's a vacant land.
That also can be ascertained, the occupation charges. What are you doing?
Nobody is occupying. Admitted position, KMC record.
No. We are occupying. Cooperative is the owner of the plot.
Mr. Mukherjee, if you are not occupying, then nothing remains.
Vacant land. I say, my lord,
That's a different thing altogether.
Property,
Because the protection for recovery of possession has been passed.
It's a vacant property.
Yes.
Not a sali land. Nobody is utilizing the property. My name has been mutated both in the record of right as well as corporation
That
record.
means you are in possession.
Corporation
No,
record
no, no,
showing,
no.
showing,
You are in possession.
showing, my lord, it's a vacant land.
Yes, that
Rather,
means
expending everything for the property right now.
that means you are in possession, Mr. Mukherjee.
Yes, Lord, I
For
am the
that,
recorded owner.
recovery of possession order has been passed. So please take a suit. It's a suit under section 5. Let us assume. And a decree for declaration of title and permanent recovery of possession is passed. On this set of facts, please substitute it. Let us consider this the first appeal.
I say, my lord,
Title declared, recovery of possession directed in respect of a vacant property.
it is really a suit, my lord, under a specified act. It's, my lord, it's a suit not under section 6. It's a suit, my lord, rather it's an application under section 6 of the specific relief act.
It's a suit. It's a suit, but appeal is not maintainable.
Being excluded, my lord, by the specified, my lord, that act itself. So, my lord, I will be governed, my lord, under this limbs of the specific relief act.
Yes, yes.
It's a
No
summary
difficulty
procedure.
on that.
It's a
No
summary
difficulty
procedure.
on that. But as a condition of enjoying an order of stay, are you not liable to put in occupation charges? Do you have an authority on that?
I say, my lord, nobody is utilizing the property. My lord,
That you cannot say. That you cannot say.
Rather, it's
No,
a
no.
property maintained by me in the
No,
records.
no, no,
and
no.
has been
Let us
expending,
put
my
it in a different way.
Maintained by cooperative.
Up to you whether
I
to
am
utilize or
purchasing from
merely
cooperative.
because you say I am not utilizing. Does it mean to say that you will not be entitled to liable to pay occupation charges?
Then, my lord, kindly direct also restraining them not to disturb my possession.
No, 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 no.
My landed friend
I am
cannot
not.
say both ways.
You cannot disturb his
cannot say
possession
both ways.
because now it has been held. He is in possession. Recovery of possession. If
I'm
you
not-
say you are in possession, then
I'm
no occupation
possession.
charges.
Cooperative, cooperative.
Are you in possession?
I am for purchasing from cooperative.
That's a different thing. Are you in possession?
Yes.
Then you are in possession.
Yes, my
Then there
lord.
is no question of occupation charges. Then there is no question of occupation charges. I am staying this. I will hear this.
Yes.
Ashun.
Fixed a date for hearing.
The judgment and order dated January 27, 2025, passed in title suit number 38 of 2013. Now, passed by the Lanet Civil Judge Junior Division, First Court at Alipur, in title suit number 38 of 2013, is under challenge in this application under Article 227 of the Constitution of India. First, Mr. Mukherjee, Lanet advocate appearing for the petitioner, submits that under mistaken legal advice, initially the petitioner preferred an appeal being title appeal number 41 of 2025, and the Lanet judge and the Lanet additional district judge 13th court at Alipur, district 24 Pogana South, by an order dated 26th of November 2025, passed an order of stay of operation of the judgment and decree. First up, he submits that thereafter the said appeal was withdrawn and the instant application under Article 227 of the Constitution of India has been filed. Full stop. In this application, in this civil division application, this court has to take into consideration the pleadings of the respective parties as well as the evidences that are on record. Have we annexed the evidences?
No, my lord, everything is not
Full stop.
No.
Evidences on record. Full stop. List this matter under the heading contested application. After 8 weeks, full stop, the petitioner is directed to file a supplementary affidavit annexing the plaint.
Call for the record, my lord. My lord, call for the trial court record. It is necessary. Various document is there.
If it is, I direct him to file from the certifier, from the copy. What is the harm? That will further delay.
Because their deeds, my lord, is not with us.
All certified copies with me.
Of the, my lord, defendant number 3.
Please, I'm giving them.
Kindly do
I'm
that.
giving them liberty also to file a supplementary affidavit to annex, or you can
All the documents evidence and
You have the copy of all the documents, his
yes,
documents
yes.
also.
Yes. All the documents is us. Documents
No, do one.
cooperative
Look, please file one comprehensive. Choose
Evidence.
both of you can file one, because unnecessarily you will be annexing 2 documents, you will be annexing 3 documents. Please decide who will be filing.
Sure.
Please supply the other side's document, exchange those documents. Who will be filing? You will be filing. You will be filing.
Yes, I will
All
file.
right, Mr. Mukherjee, give your
Yes, yes.
documents.
Whatever documents my learned senior friend has,
The
but I will
learned
hand over.
advocate appearing for the opposite party volunteers to file a supplementary affidavit annexing the pleadings and the evidences which were before the learned trial judge. Let such supplementary affidavit be filed. The learned advocate on record of the petitioner is directed to supply the copies of the evidences of the defendants
Defendant number 5 and 6.
of the defendants witnesses of the evidence of the witnesses of the defendant numbers 5 and 6 as both oral and documentary to the learned advocate on record of the petitioner within
Learned advocate for the caveator.
sorry for the caveator within
3 weeks. Within 3 weeks.
within 2 weeks you supply.
4 weeks.
Why certified copy? How could you make this civil division application ready?
No, but the evidence on my side which was adduced, documentary evidence regarding the
Must be having the copies of that. Certified copies which will take a long time.
So Chattopadhyay is saying, he's not having those.
Then the records are to be called for.
It's better.
Otherwise, Mr.
I believe, it's better. By this process, how much time will be spent? The records will come up before this honorable court. Because it's from.
Sir, can you? They are trying to delay. I'm telling you, sir. They are trying to delay. Can you take the certified copies?
Yes, yes.
Please take it, because they will be delaying. Because they are in possession, they will be delaying.
Contesting.
The learned
Another the other non-appearing opposite party, because my learned senior friend is for the plaintiff caveator. So I will have to serve the other contesting defendant.
The video document already. Other contesting defendant is
affidavit,
New Godia Cooperative.
Within a period of supplementary
Is the
affidavit.
necessary party contesting the trial court.
I will direct, sir. I will direct. How much time we will file this supplementary
3
affidavit?
weeks. 3 weeks.
Within a period of you have to obtain certified copies. You can do it by 3 weeks.
Already.
Within a period of 3 weeks from date, first petitioner is directed to serve a copy of this civil division application upon the opposite party numbers 2 to 5.
No, three contesting 3.
2
Only
to 5,
cooperative.
and file an affidavit of service on the next date. There shall be an order of the learned advocate appearing for the caveator submits that they are in possession of the property in question. First of such submission is disputed by Mr. Mukherjee. He submits that the petitioners are in possession of the property in question. First up, there shall be an order of stay of operation of the judgment and order dated 27th of January 2025, passed by the Learned Civil Judge Junior Division, First Court at Alipur in title suit number 38 of 2013, till the end of the month of December 2026, or until further orders.
December.
Yes, or until further orders, whichever is earlier. Yes, call the next matter.
December of the
No.
Yes, Mr. Mukherjee, you are not happy.
Lordship directed the matter to appear?
Directed to matter appear before?
On.
6 weeks.
6 weeks.
The next matter, Milord, the advocate, Milord, somebody, Milord, occupies the chamber of the advocate, Milord, without paying any rent, Milord, there is a occupying, Milord, there is the eviction suit, Milord. Milord, 2004, Milord, filed a eviction suit. Till today, neither filed 7172 nor paying any maintenance, Milord. Only
Application under Article 220. Yes, next.
In this matter, I am appearing also. That this matter, my lord, the opposite court might have filed an application under section 8 and 9 of the.
Under section?
8 and 9 of the West Bengal Administrative Preemption. That
Yes.
application was dismissed. On the count that the entire should not have been transferred. Thereafter, they prefer an appeal. But appeal court set aside the judgment of the trial court and passed my lord decision. That point was still pending, my lord, whether the entire suit plot is transferred, then application for preemption is allowed or not.
It's pending before the larger bench. The
I am the defendant number 6, my lord.
I'm being led by Mr. Thakkar. May I come back in the second, my lord?
My lord, I'll just indicate shortly, my lord.
Yes.
I am the defendant number 6 in a defamation action. My application under Order 1, Rule 10, my lord, was pending because I was not a party. My lord, the allegation in the plaint is against the defendant number 1, and that certain communications were forwarded by the defendant number 1 to directors of certain companies, one of which is, my lord, my client, which is the defendant number 6. Now, my lord, on 6th of, my lord, November, my lord, we filed this application saying that there is no cause of action against me. This was pending. Directions were issued for filing WO. My lord, on 4th of December, my lord, this happened on 6th of November. On 4th of December, my lord, the principal defendant with the, my lord, plaintiff, they enters into a settlement. This is also recorded in one of the orders. They now dispute the settlement. Pursuant to the settlement, maximum proceedings withdrawn, some are left. My lord, there is an issue pending with regard to that. By the order impugned, my Order 1, Rule 10 has been rejected only on the ground that there is no letter of authority. And my right to file written statement has been forfeited. And my lord, the suit now proceeds ex parte against me. On 4 occasions, my lord, the matter was adjourned because of the, my lord, pending settlement.
But your Order 1, Rule 10 has been rejected.
Only on the ground that there is no letter of authority. My lord, kindly takes, my lord, the certified copy of the order. Kindly comes to 6th November order once.
Unless there is authorization, Mr. Datta, can you file an application?
Always be ratified. My lord, kindly sees, my lord. I will show, my lord, one authority for that. My lord, lordship is aware, my lord, Order 6, my lord, Rule 14 and Order 29 provisions, my lord. Every time it can be ratified by the company. And there was, my lord, an authority. My lord, there was, my lord, it was not only fixed for that hearing of Order 1, Rule 10 application on that day.
All right, come at 2 p.m. Yes, call the next matter. Yes, Mr. Basu, any problem?
A problem is there. I opened my tiffin box and said, my lord is not right. So I have come. I have to come.
I think after opening, you did not like the thing which is which was inside the. That is why you have closed it and you have come.
Not my life. For Lokhi, I have come. Not for anything. My maintenance towards my wife is required to be reduced after my retirement has been enhanced.
Has to be enhanced. Looking at the appearance, Mr. Basu has to be enhanced.
My lord, I was in the service. Thereafter, I retired from the service. My maintenance has been enhanced.
Even then, Mr. Basu is appearing for that. It shows that's an indicator that it is to be enhanced.
Is this Is this the perception of Mr. Hiranmoy Bhattacharya while in this side of the bar? In every matter, my lord, there is.
So far as Mr. Shobhatu
Oh.
Basu is concerned.
Not others. Not others. But can you
Stature of the council who has been engaged.
can you see? We are all are hungry. Can you see this? Let them come, my lord. Can you stay for the timing?
What stay? Pay, after all, Mr. Basu, after all, you will be paying to your wife,
Allow me to
not a
conclude.
third party.
Allow me to conclude. High Court directed for pay of 45,000 per month. Now it has been enhanced to 63,000. 45 can you allow me to pay? Rest let them come. ঠিক বললাম তো সব?
Daughter, Mr.
Yes, 45 High Court directed.
What is the age of the daughter, Mr. Basu?
She is studying.
18.
Studying where?
She is studying.
So the education expenses is by Mr. Basu. After all, he will be
Giving, in addition to this, I am providing the education.
it's Techno India University admission. Mr. Basu,
So considering this, High Court directed
you
45.
have retired when?
After retirement, I file an application for reduction. This is the result.
2022.
22, I have retired, my lord. Can you allow me to pay 45, which was paying in terms of the order of the High Court? Your lordship will get that figure in the top earlier part of the your lordship, the order impugned. 45, let me allow me to pay. If there is an area, that also I will pay.
How much are you paying? 45,000 now?
No.
Why?
What happened? Wait. Let me tell the truth. 45 was the direction. I don't know. This is the what is that think of my client? The moment he retired, he reduces up to his own. That I am required to pay. I must concede before my lord. I will pay. Can you allow me to pay 45,000 and area, my lord, give some installment?
45,000 you liquidate and now you pay something more because some enhancement is there. Thereafter, I will consider.
My salary has been slashed down. Salary and pension, my lord knows. That's why I have not opened the brief. I said this is the only point I can canvass before my lord.
What were we doing?
I was an employee
Of
central government.
what was your last drawn pay?
Considering that, my lord, 48,000 your lordship's court directly.
I'm asking you, what was your last drawn pay?
That all has been disclosed.
What was your qualification?
I will show to you, lordship, the calculation is also wrong. Cash in hand has been shown to be my monthly income. Can it be?
Yes, sir. 12 months after that, that's the balance. So it must be on an average basis, maybe more, but in the
that cash in hand
month of March, Mr. Basu, you knows the expenses are more in the month of March, so it has reduced. So average it can be taken.
Cash in hand be my income.
Not the income, the
That is also shown by the court. Cash in hand also my income.
income.
Yes.
So maybe in a different way, you have that money to.
No, I kindly direct me to pay 45,000, which my lord's court directed, which has been abruptly reduced. It should not have been.
Mr. Basu, learned senior
It is suits by the warden of the court is before puja, before independence also. কি করবো? He is unable to pay. Can you make it end of August? He is also providing something in
Because
addition
for
to
the
that.
daughter, maybe for the wife, it is reduced.
In addition to this order, my lord, my client is paying something, whatever is possible for him. I had a talk with him. I advise him to do that because daughter is yours.
After all, you have to consider it's the daughter's education that should not suffer. After
Now,
all,
my client is present in court. Hard, my lord. We lost your
that's
observation.
after all, you have to.
Oh yes, 6 months semester fee has been paid by my client.
Mr. Bas September monthly. It is however made
My lord, but I want to, please give me leave to file this application with petition without the certified copy of the order. I have not received.
What is the urgency?
Urgency is that it is an application where the section 47 of the CPC has been rejected. I am filing an civil revision against that order. The contempt, the execution proceeding will be is on Thursday in the lower court. And before, if we don't file this matter, then the execution proceeding will proceed and bank will
When the order was passed,
order was passed on 13/7/2026.
what were you doing for this long?
But they have not. They have not applied.
When have you applied for the certified copy?
14/7/2026.
You have not yet received.
We have not received.
All right, file it.
Permitted to mention, Madam, Act number 132. Madam, from fixing an early date, my lord, as the matter fixed before
Let me see. Yes.
court below, my lord, is on 13th of this month, my lord.
Yes. Call the supplementary list. Yes. Tahun. Yes.
Yes, my lord.
I'm waiting for the private respondent.
Well, the proceeding under
Private respondent.
yes, my lord.
Private
Who
respondent.
has initiated the proceedings?
Private by the SDO.
STO. State have you served?
Yes, my lord. I have served.
Under what proceedings?
Yes, my lord.
Under what provision of law?
62 Act. Eviction.
62 Act.
Yes, my lord. Mr.
But they challenge that
My lord, Shobhan
case
Mukherjee
72.
and Abhishek Chakraborty are appearing. I have served a notice.
Who is appearing?
Shobhan Mukherjee and Abhishek Chakraborty.
Where are they? Have you intimated that it will be taken up at 2?
I have, yes, my lord. That is how I have served the notice, my lord. আপনি আছেন? State. Oh, my lord, state is appearing.
My lord, in this matter, my lord,
You are appearing for the state.
my lord, I am junior, my lord. I called Shobhan Mukherjee, my lord. He is on his legs, my lord. He is on his legs, my lord. So Shobhan Mukherjee, my lord.
My lord, I have challenged an order issued by the BDO concerned, my lord.
The last challenge of page 72.
4th August 71 is the notice of eviction issued by the BDO, my lord. It was received by the petitioners on 5th August. My lord, the demolition is scheduled on 11th August, that is today, my lord. My lord, the difficulty is, if I may place the notice, my lord, once.
Yes, the order was passed on 18/11/2025.
He has not stated, but that is submitted. This is the order. 18 November.
Submit, my lord. We have not been served with any order, my lord.
Can you see? They are present. It has not been stated in the petition. Can you see top? Sarobindu Mahato, Nitai Hala, Sajjan, they are present.
We have not been served with
Next
any
page.
order, my lord.
Next page, my lord. Next page. Order number 5. 18 November 2025. All are present. Private respondent present. Petitioners, where the my clients was the petitioner, they are present. All are present. In their presence, order was passed. He has not stated that is totally suppression of the fact.
Statement, my lord. On
Totally
the
suppression.
You have
of
a
fact.
copy of the 62 Act.
Yes, that act, yes. There's a provision for preferring appeal.
My lord, there are two grounds
Let us
of
do that.
challenge over here, my lord. One is we have not received the order of the SDM or SDO.
You ought to have challenged that order, 18 November. Can you see paragraph 14?
Second is the SDO cannot pass an order under the 62 Act.
Who can pass?
The DM, the collector. My lord,
Collector?
kindly see- Yes, my lord. Yes, my lord. Collector, kindly see.
Power has been vested to the STO,
Yes.
sir. If you are taking that point,
Yes.
sir, there's a notification.
No, my lord, there are
Power STO has been vested with the authority to exercise the powers of the collector under the 62 Act. So if you are taking that point, it can be right
first
now.
point is
Or can you see paragraph
my
14,
lord, my
paragraph
first
13 and
point
14?
is first point is
And I have delivered a judgment on that. Mr. Kaushik, they appeared in that matter.
well, the first point is the order which is referred to in the eviction notice that has not been served upon us.
was present. He ought to have stated in the petition.
We were not
Paragraph
present
13
on
and
the
14.
date and time of hearing.
And he said paragraph 13 and 14.
Learned SQ was not there. We
And he
submitted
stated that
a petition. Yes,
present
I
that
have
order
stated
was
that in my
passed.
Mr.
petition.
Bhattacharya, you
I have
had your
stated
lunch
that.
or you did not have? You had your lunch.
I have stated that in my petition, sir.
Yes.
What was you? You have stated.
Yes, you are hard and an order has been passed.
The order was not served upon us.
All right, you are hard.
My lord.
You are hard in that proceeding.
Hearing-
Have you stated in this
Yes, my lord. I have
writ petition?
stated that
Please
order
show me.
was not served. I'm
Yes,
coming.
you
Paragraph 14
participated, you are given an opportunity of hearing. Where have you stated? Please show me.
Paragraph 14, page 8.
Mr. Bhattacharya, please allow him to submit. It is his petition. Let him make his submission. Yes, please show me.
My lord, there is another ground in the notice of eviction. The plot number mentioned differs by a long shot with the plot number mentioned in the proceeding before the SQ. The plot number mentioned in the eviction notice is 638/2669, and the proceeding was conducted for 438/2669.
Yes, what is your instruction? Are you taking steps? Have you taken any steps?
My lord,
Stay your hands. If you stay your hands for 2 days, I am keeping it before the regular bench tomorrow.
My lord, paragraph 22 I have stated.
With the instructions, we've just received the brief.
Please don't take any steps for 2 days because you have kept quiet from November 2025 till this date. So you have not done anything.
Just keep it
No.
day after tomorrow morning. I'm coming with the instructions, my lord.
So don't take any steps. I'm directing this matter
Keep it in Monday, my lord. I'm coming. Keep it in Monday, my lord. I'm coming.
Monday. All right.
My lord, paragraph 22 I have stated. I have not been served with the order, my lord. Paragraph 22 at page 10. I have stated.
No.
Now Mr. Bhattacharya is having the copy of the order. So
yes,
I understand, my lord, but we have a recourse against that order, my lord. But we have been denied of that opportunity.
What order you stated? What was stated the appeared 18th of order was passed.
the
Once, my lord.
Yes, well,
Only the
Thakkar has
impute.
come.
It's still engaged before court.
It's still engaged.
My lordship gives me 2 minutes. My lord kindly gives me 2
Doctor,
minutes.
is it so urgent? I can
No,
take it up tomorrow.
My lord, I'll just seek one direction if lordship, my lord, feels that is necessary. My lord kindly comes to the impugned order once.
Yes.
He has told me, my lord, he has told me that Mr. Thakkar would be busy.
Yes.
My lord, impugned order. What has happened is, my lord, by the impugned order, I am the defendant number 6 in a suit for defamation, where there is no personal allegation against me. It's really against the D1, who has, my lord, issued certain correspondence. My lord, the order 1 rule 10 application has been dismissed. My right to file written statement has been thereafter forfeited, only on the ground.
You have not been added. Where is the question?
No, I am. I wanted striking out. I am a defendant number 6 in the suit. I wanted striking out.
Oh,
of my
striking
name.
out. I
Yes.
want.
So
Yes.
order 1 rule 10(2).
Yes.
So my lord, the only ground on which this is done is that there is no board resolution, letter of authority, or power of attorney.
6 occasions.
My lord, this is after 5 occasions when, my lord, this hearing was adjourned from time to time on the ground of, my lord, settlement between the principal 2 parties. My lord, I have the copy which was filed, which is, my lord, the power of attorney giving power to the, my lord, deponent who has filed the order 1 rule 10 application.
Please
What I
give a
was
copy
seeking,
to him.
what I was seeking is lordship only calls for the records. If lordship the records are here,
Please give a copy to them. Let them verify. I think if it is in record, Mr. Thakkar will not deny that.
my
Please
lord,
give a copy to them.
has opposed it there, my lord. He will not take a this is a, my lord,
Milord, we have
hotly
obtained,
contested
we
litigation.
have obtained, Milord,
Hotly
the
contested
certified copy
litigation.
of the records, Milord.
They will never,
That-
my lord,
that
they
is
will
not
never,
there.
my lord, accept that this power of attorney or this letter of authority is there to avoid, my lord, further delay. I was only seeking a direction, my lord, from this court to call for the record.
Milord, that is because, Milord, the date is fixed and
That
in a
will be.
Otherwise, I would be praying for stay of
Entire
the
suit
proceeding.
will be.
My lord, then, my lord, I would be entitled to, if lordship is with me, to, my lord, interim order of staying this
What is the next date?
20th of August.
Milord.
So I'm keeping it tomorrow. So please give a copy of this letter or this petition or that letter to him so that he can take
My
instructions.
lord, he already has it. I have served him.
No, Milord, these copies we do not have it. On the contrary, we have
That is why
applied
please
for,
give
Milord,
it
the
to him.
certified copy, and in the certified copy, Milord, it was not
Please
found.
check up, ask your counterpart
Milord,
to
I
verify
shall do that.
because Mr. Dotto is saying that this is lying in the record.
I took this instruction during recess
Please
to
check,
ascertain before making this submission.
Ashun, Mr. Dotto, learned advocate appearing for the petitioner submits that though the letter of authority,
This is power of attorney.
though the power of attorney, though the power of attorney was filed before the learned trial judge, but the impugned order was passed without taking into consideration such power of attorney. So a copy of the power of attorney is supplied to the learned advocate for the opposite party who seeks an accommodation to revert back with necessary
My lord
instructions.
keeps it
Tomorrow or day after tomorrow?
Milord, I shall take instruction, Milord, right to
Tomorrow? This is better tomorrow. Yes, next.
My lord, may it retain its position, my lord. As
28, Milord, I am waiting for the petitioner in this matter. Petitioner in this matter. Now, Milord, father is the petitioner, Milord, plaintiff father.
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 Again child.
Now, Milord, I applied for visitation, Milord, kindly turns to my...
What happened? Rejected?
No. Court allowed it, but kindly sees the manner of allowing. This is where, Milord...
Which order?
Order number, Milord, 17/2023, 1st of July, order number 18.
Every Sunday, 11 to 15.
Yes, 4 hours.
The house of the
respondent.
Yes.
Milord, in one single room, Milord, a child of 5 years. And Milord, the wife raises an allegation that I've been trying to steal the child from the house. And there are cases, counter cases. Milord, it becomes difficult. And Milord, my specific instruction is, Milord, for three years we have been living together with the child. And child is so happy with me. He is willing to go out with me. Milord, if nearby parks are allowed, that was my prayer. I can take the child to the nearby park so that we can play. And Milord, child is of 5. 3 years we have spent together. It's not that I am new to him.
Mr. Chatterjee, it's better if you want, you file an application for modification there.
I have already prayed for that.
Where is that?
Milord, kindly takes up, Milord, my application.
What happened to that application?
That is what the order is entirely disposed of. Milord, with the interim prayer. Milord, I have 2 prayers, one for the custody, interim measures, and Milord, interim measure taking out the child, Milord, having other spending time with the child. That was disposed of in this interim manner.
How long you could not contact your child?
My lord, even after separation in 2024, my lord, I was visiting. That is admitted by both the
What
parties.
is the age of the child?
Child now 5 years. My lord, we have been constantly, my lord, visiting. And my lord, the wife gives consent. My lord, that's what important is, my lord, in the order. My lord sees the consent of the wife. The second last page. My lord, kindly turns to the
Mr.
second.
Chatterjee, learned advocate appearing for the petitioner submits that it is difficult for the petitioner to exercise his visitation right at the residence of the mother opposite party here. He submits that a neutral venue may be fixed for such visitation. The petitioner is directed to serve a copy of this application by register speed post with acknowledgement due and file an affidavit of service on the next date. September motion. Yes, next.
29, my lord. I am for the petitioner. This is for expeditious. Let my junior move. But my lord, this is of 2025 suit, my lord, I must say. If my lord allows me. My lord, only-
2025 suit.
Yes, but my lord, suit
What
has
is the
reached
stage?
stage issue framing. My lord, now, my lord, after the issue.
What is the suit for?
Suit for, my lord, eviction of licensee. Now, my lord, I am a cancer patient. Now, my lord, my stage are terminal. Now, my lord, if for the issue framing, my lord, it is
Charge court, Mr. Chatterjee.
exactly,
How
my
can
lord, I am terminally ill, my lord. If my evidence goes, my lord, PW2.
But charge court, Mr. Chatterjee.
Kindly directs the charge court to proceed. My lord. Otherwise, my lord, if I am terminally ill, my lord, my problem is, my
Mr.
lord,
Chatterjee, it's difficult. Please consider here also it is happening. We have been given determination for some honorable judges on a particular date. It's difficult for us to take all the matters.
now, my lord, if the
Exceptional matters for some interim protection that is there. How can a suit be decided by the charge court, Mr. Chatterjee?
my lord, he's from that court, my lord. That charge court now the court has joined.
Regular presiding officer has joined.
Yes.
When?
1 month has gone.
All right. So I'm recording your submission that in the meantime, this application under article written statement filed.
Yes, yes. Written statement filed, my lord. Date for framing of issues are fixed.
Written statement accepted.
Accepted.
You have not challenged that order.
I'm not challenging. I want to, my lord, because eviction of licensee, value of rent is 75,000. 106 notice.
That is why you are not challenging. This application under article 227.
Before I can trouble your lordship with the
For?
Lordship, this is for your lordship. This is lordship, which is why I was attempting to your lordship trouble your lordship first with my submission before I can indicate the papers. Lordship, the impugned order is in the nature is under order section 36 of the Special Marriage Act, by way of which your lordship I had a maintainability application under 151 with respect to maintainability of the application under section 36. By the impugned order rejects my application of maintainability. Now, your lordship, before I can trouble your lordship,
What is the mentality point?
Your lordship, which is what I am on, your lordship. Before, because your lordship, otherwise, your lordship, if I can close my brief also, your lordship, I have a bad case here. But your lordship, otherwise, because I, as an officer of the court, I must come clean. Otherwise, but your lordship, which is what I am attempting to showcase, your lordship. Lordship, I may be a person who is having interests or who is a designated person antithetical to the interests of the society. But, lordship, the law of the land is such that I will still have to be given an opportunity. The due process of law has to be followed. Lordship, today bereft because I am in civil revision, your lordship, I cannot really go into the merits of my application. But your lordship, what I am really on, your lordship, if the learned trial court tomorrow is relying on a judgment unilaterally, so the basic, your lordship, principles of natural justice perhaps demand that your lordship, an opportunity is given to me to deal with that judgment and come back. I may be right, I may be wrong. That is, your lordship, for a different proceeding altogether. Lordship, what I am agitating.
What is the order which you are challenging?
Lordship will kindly take order number 50, 20th of February 2026.
Order number 50.
Order number 50, that which is the last order of my CO application.
No, why are you saying that its application is not maintainable?
Your lordship, bereft of that, your lordship, my application for your lordship for annulment of marriage was premised on a ground of fraud. Your lordship, my contention before the learned trial court.
So that will be decided. Now it's the alimony application. So alimony application, why it's not maintainable?
Your lordship, at the time when we had filed this application, the law stood as such. There were conflicting judgments of the Supreme Court, which says that when fraud is involved, your lordship, perhaps then the question of interim maintenance of alimony pendente, like your lordship, that cannot be granted. Subsequently, your lordship, I am given to understand by this order that there is a judgment of the Supreme Court by way of which these conflicting decisions were referred to the larger bench. Larger bench came out with the view that, of course, your lordship knows Ronalds versus Ronalds English decisions that maintainability cannot really stop your lordship
Maintenance.
applications with respect to maintenance. Or
so now I am directing the alimony application to be disposed of.
No, your lordship, that will in fact, your lordship will counterblast me. But your lordship, may I go back before the learned trial court? Your lordship,
or what?
Distinguish the judgment. I am
now distinguish if the larger bench has.
No, I am not aware. I can distinguish.
Now you are aware.
Your lordship, which is why that opportunity ought to have been provided to me. I am carrying.
Yes, now you are aware. So that's the position of law.
Perhaps not, your lordship. I can still distinguish it on factual circumstances, because your lordship, even otherwise, fraud, your lordship, goes to the very vitiates everything. So your lordship, even prima facie, where there is no marriage in the eyes of law, your lordship, this application perhaps is not maintainable, which is why, your lordship, I am refraining from making submissions on merit. Lordship will kindly take. I am relying on one judgment of the Honorable Division Bench of this court.
I'm a copy company then. I'm a caveator. Caveator.
Actually, we are the caveator.
Caveator, copy not served.
Yes,
But no,
the caveat.
nothing has been served upon us.
Yes, caveat noting is there.
Your lordship will give
That is the tragedy. And not only that, they are flouting several orders of different court by not furnishing their assets liabilities by law.
Yes, Mr. Chakraborty, please.
That is the just to first state.
No, your lordship, I am giving a copy right now. Maybe.
And not only that, my lord, probably they did a mistake. Probably, I do not know. In E-Court, what I find that is order passed 6th additional discharge, not that.
E-Court reveals.
That E-Court reveals.
Order? No, I could not follow.
Actual order passed by the learned additional district judge 8th court. But
Yes.
in E-Court, what I find, they preferred this revision by Lord, mentioning 6th court in the E-Court, through E-Court.
E-Court.
I do not know which one is correct.
8th court order is there.
8th court.
8th court.
Yes.
And that is why we are the caveated by Lord. We filed the caveat on 24th June 2026.
But Your Lordship, that caveat on instructions I'm submitting, that was not served on us. Your
Yes,
Lordship,
yes. It was served,
even
it
in
was
the
delivered.
even in the department, my learned advocate on record has taken
Mr.
inspection.
Chakravarti, when your clerk has filed,
Yes, Your Lordship,
first is caveat checking, this is the noting, so your clerk was aware of that.
Lordship, I've
Now you
given my-
cannot take the plea that it was not served.
Your Lordship, I have given my learned senior a copy of the CO application. I am not on anything. I am not relying on this document at all except for the impute order.
My
And
page
one
is
judgment of the Honorable Division Bench of this court. Your Lordship will kindly take. If I don't have a case, Your Lordship, I ought to, Your Lordship, walk out of this.
Give me a copy.
Sir, it up.
my lord, over the issue, one coordinate bench of this honorable court, my lord, what happened on 10th October 2023, just expressing his inner pain, says that within 45 days, the matter of alimony application or the maintenance application, and they are challenging the maintainability in different court, my lord, without furnishing their assets and liabilities.
Not a matrimonial suit.
Not a matrimonial suit. Your Lordship, on principles of natural justice. Lordship will kindly see once. Lordship will kindly.
They are
see on
avoiding.
paragraph number
Please
39.
show me a decision on matrimonial suit.
Lordship will
That when
kindly-
you have filed a suit for annulment of the marriage on the ground of nullity, alimony application is not maintainable, Mr.
I am
Chakravarti.
not on that, Your Lordship, which is why I
That's
came
the
in
issue,
and
Mr.
said
Chakravarti.
that, Your Lordship, I perhaps have a bad case. But Your Lordship, principles of natural justice, Your Lordship will kindly see, Your Lordship, over here what happened, the DRET and the DRT, Your Lordship, perhaps relied on certain
That is
Well,
on a different
even
footing.
under arbitration jurisprudence, Your Lordship, when the arbitrator is unilaterally relying on decisions and Your Lordship returning a finding, Your Lordship, awards are vitiated on count. Any judicial order which relies on a authority without giving either of the parties an opportunity to deal with it, Your Lordship. I am not asking for anything else, Your Lordship. As an officer of the court, I will not even ask pray before Your Lordship to
Which
set aside
judgment
this
you want an opportunity to deal with? Please show me.
Your Lordship, the judgment which I want an opportunity to deal with.
Yes.
Your Lordship, this is the judgment which has been referred.
একটা দিন একটা কপি দেবেন
See, এটা তো referred আছে। আচ্ছা আমাদের ও এই sorry. This Your Lordship was under the 1955 Act, the Hindu Marriage Act.
করাটা হতো
Paragraph 27 and
Lordship, I bow down to that. Your Lordship, 26, 27, 26, it's oddly numbered.
Yes.
Our view in question number 2.
Yes, so this
kindly
side-
appreciate, this is not on a question of fraud. Not on a question of fraud.
Maybe.
Your Lordship, Your Lordship will kindly appreciate, Your Lordship, fraud perhaps vitiates all acts, Your Lordship. And it goes to the very root of the jurisdiction. Your Lordship will kindly allow me to distinguish this judgment.
What
before
is the effect of fraud?
Your Lordship, when fraud
What
has
is the effect of ultimate effect of fraud?
Because Your
It's
Lordship,
void. Actions are
void
void.
and not voidable.
So,
Not voidable.
so here it says void, voidable both.
Voidable vote.
So it takes care of that.
My lord, just on 7th, my lord, coordinate bench of this honorable court, actually after going through the tactics, not furnishing the assets and liabilities, and challenging one after another maintainability application
That is a
against the order, my lord, passed to different court. What happened just on 7th coordinate bench of this honorable court rejected their admission hearing on quashing application.
But Your Lordship, that is an avenue available.
My lord, they are not yet since 2023 till date.
Please show me what is the ground of fraud taken in the plaint.
Lordship will kindly look at my 151 application, which is at page 100.
Not 151, in the plaint.
Lordship, the plaint, Your Lordship, will kindly see.
Because you have to make out a case of fraud in the plaint.
Lordship, we have the only issue which I'm facing right now, Your Lordship, is the complaint has not been annexed in this application.
I can take it. Have you made out a case of fraud in the plane? Please show me that.
Which is why you marriage certificate. Lordship, may I take your Lordship first to page number 95, which is the marriage certificate. It won't. Your
I
Lordship
will
wants
not-
to see my pleadings.
Pleadings.
Pleadings, as such.
Please,
Your Lordship,
please
the
show me what was
plaint
the
is not
ground
there.
of
Your Lordship
fraud
will kindly take
taken in the plaint.
my non-maintainability application, Your Lordship, at page
Not
111.
non-maintainability, Mr. Chakraborty, please show me the plaint. If
Lordship,
you have not taken the ground of fraud in the plaint,
I can't take it anywhere else. Of course, Your Lordship. Your Lordship,
Marriage was there, honeymoon is there in Nepal, everything.
marriage,
Now,
what marriage, sir?
now
We
this
will
is
address
going
on
on.
marriage.
Since 2020 till date, they are avoiding to furnish their assets liabilities so that no competent court will come to a conclusion
are you
regarding
ready
that.
on facts or you want to come back?
Pardon?
Are you ready on facts or you want to come back on another day?
My lord, if your lordship, more or less I am ready. Because today my pain is, my lord, no copy has served, and that is the reason.
Now you are served.
Yes,
So if you
yes.
want to come back on another day, I can fix it another day.
His Lordship, that
Ready. We are ready.
Not to my interest also, Mr. Shuddhaswatta Banerjee.
I am
is
ready.
leading me in this matter. He can come and perhaps embellish your Lordship.
Just seventh,
So
question
he's leading you.
Mr. Shuddhaswatta Banerjee.
I will not allow him to argue. You have to argue.
Lordship gives
To
me
make yourself ready, please bring the copy of the
I'll
plaint.
bring the copy.
Yes.
Then Monday. My lord, Monday.
Monday.
My
On
pain is not yet furnished their
on the
assets.
on the prayer of the land. Yes. Expeditious hearing. Please speak to the microphone. What is the application dated 15th of July 2026? What application was filed on 15th of July 2026?
My lord, this is not my, this is my senior matter, my lord.
This application under Article 227 of the Constitution of India is
Your Lordship, I have instructions to appear on behalf of the bank. There is also a caveat, but I would be candid that in caveat, the order date was incorrectly typed as 26 instead of 28, but no copy has been served upon me, my lord. Let a copy be served upon me. I'll come back tomorrow.
Please serve a copy.
No, I'll serve the copy, my lord. I'll serve the copy. My lord, only one thing, my lord.
Interim order.
My lord, I
Possession has already been taken, my lord.
my lord, possibly, my lord, I don't have a scope, my lord. Your lordship will only read 2 paragraphs, my lord. Perversity, my lord. Perverse on the face of it.
Without.
My lord, your lordship kindly sees.
Now, what are you seeking? What is the interim order you are seeking?
My lord.
Not to take any coercive steps to take possession. Possession has been taken.
my lord.
So there is no scope to pass an interim order. Please serve a copy.
I'll come back tomorrow. I have no.
I'll come.
Please serve a maintainability of the revision petition.
Yes.
Suit for eviction has been filed on behalf of the petitioner.
Suit for?
Suit for reasonable requirement, default and change of user. And the tenant.
You are the?
I have the land. In the counter blast, an application of suit for declaration of tenancy right has been filed on behalf of the tenant. In that suit, an application required has been filed. The repaired application, you will find there is no schedule. The court filed, the London advocate for the opposite party tenant files an application that I want to repair the suit property. The court so more to directly repair it, don't change the design character. You also kindly sees that photograph of the. It has to be reconstructed. Therefore, my lord.
Reconstructed?
Yes, it has to be reconstructed.
Oh, it has to be reconstructed.
My lord, your lordship, see, this is the situation is, my lord, this is not, your lordship kindly comes to the application for repair. My lord,
This repairing application has been filed in a super declaration of tenancy right.
Tenancy right. Kindly come to page 26, your lordship kindly comes. And this is the application for repair. Now, my lord, your lordship will kindly comes.
No, you filed an objection to this.
No, objection could not be filed because we are not given an opportunity to file the objection to the application for
repairs.
Repairs. And you also can see there is no schedule which are the portion they want to. No commission has been done. My lord, ex parte, this order was passed without giving a chance to controvert the allegations made in the repair application. You also kindly seize the impugned order. The property is in a deliberate condition. Plaintiff has paid for repairing damaged bamboo shed, damaged files, shed, and the wooden roof of the super at his own cost. Where is the schedule in the repair application? And my lord, this is a mandatory. My lord, your lordship knows that I can show you a lordship.
Defendant is absent without any step. Mr. Ghosh, what can be done?
No, my lord, what happened, my lord? The copy was not served on him. Therefore, he was not aware the matter will be taken up to other. Apart from that, my lord, I don't take that plea. My lord, to have, my lord, the court ought to have seen the schedule. Without schedule, how the court could have passed an order?
Mr. Ghosh, learned advocate appearing for the petitioner, may be just
But I am the decree holder. My lord, your lordship need not open your lordship's for timely.
Bad case.
No. But I am the decree holder in respect of a specific.
Why are you giving stress to that expression, Mr. Mukherjee?
Because of my agony. Because an agreement for sale that was entered into in sometime 2002, part performance of which has already been done, one of the deed executed. Thereafter, I had to, my lord, come to the suit for the purpose of rest part performance of that agreement, over which summons served, my lord, thereafter ex parte, judgment passed. At the time of execution, Order 9, Rule 13. Order 9, Rule 13 coupled with Section 5. Section 5 application.
What happened? Allowed?
Section 5 application allowed, wherein, my lord, the judgment debtor admitted the signature in the AD card. And on admission, that AD card, my lord, in the suit summon has been, my lord, taken into evidence.
Section 5 allowed, Mr.
Mukherjee. No, my lord, that chapter
27.
over. That chapter over. My lord, the Section 5 allowed, I challenge that. My lord, I defeated before this honorable court, since the leniency has been, my lord, this kind of application should be, the court should take a, my lord, liberal view. Thereafter, I gone back. Now,
thereafter,
I gone back, my lord, to, my lord, here
Order 9, Rule 13.
Rule 13. The Order 9, Rule 13
has been allowed.
No. The case is of non-service of summons. They have adduced their evidence. At the time of, my lord, adducing my evidence, the learned judge opined that once I allowed your Section 5 application, so once you defeated up to the Honorable High Court, so you don't have any case in Order 9, Rule 13, I will also allow. So this is the expression, and my lord would get, my lord, from the one of the order I have annexed, that the learned judge, while going on cross-examination of my witness, suggested that on the next day, if you do not close, I will start argument. So on that score, I filed a Section 24 application. Section 24 application, the learned put up application is being filed. The learned district judge.
Section 24 is before the district judge.
The learned district judge, keeping in view that tomorrow is the date fix of the miss case, fixed the Section 24 application on 20th August. Now, who will suffer, my lord? May I say? It's me. I am the decree holder. My decree has been stayed in Order 9, Rule 13 case. Why the court is on such a hurry? Because I am on the loser side, even as on today. Because I, though obtained a degree way back decades ago, my decree has been stayed in Order 9, Rule 13 proceeding.
Mr. Mukherjee, was the ground under Section 5 and Order 9, Rule 13 same?
No. I have. That's why, I am carrying this order. Kindly see. Whether a one-liner observation by the learned trial judge at the time of allowing Section 5 application that it is a case of non-service of summons. Then, Lord, your lordship is absolutely right. There are certain classes of cases, my lord, where the Section 5 allowing is amounting to, my lord, allowing the Order 9, Rule 13 application itself. I have gone through, my lord, the entire order, the narration of facts, and thereafter a liberal approach is being taken. Though, my lord, it's marked, my lord, kindly excuse me. That portion, my lord, your lordship will get the AD card of the original suit summon, the judgment debtor on admission that has been marked exhibit. But till then, my lord, a liberal approach is being taken. I am not on that. It's me, my lord, who is suffering. Let me, my lord, place my Section 24 application. And I have annexed, my lord, the learned judge's order, the last copy, order number 96, the last page of my lord's brief. Considering the direction for expeditious trial, while, my lord, disposing of my civil revisional application, challenging the allowing Section 5 application, the learned judge taken that aid, and the cross-examination of one of the witness, OPW1, has not yet completed.
This is by the trial judge.
By the trial judge.
Where is the district court?
District court, my lord.
You are challenging that order.
District judge, my lord, I have, my lord, filed, put up application moved. It has been fixed on 20th.
No, which order you are challenging?
No, my lord, there is no order. That's why upon leave.
You are challenging what?
Page 45, your lordship, kindly see. My application and put up application I have annexed. The next date is 20th August.
Yes, so you are agreed by that.
Yes.
So you wanted that this should be taken up prior to 12th of August.
12th of August.
Section
I am suffering. It's me.
Sec- Section 24 was filed when?
Section 24, 3rd August.
Mr. Mukherjee, 3rd of August.
I am
You
not
cannot
blaming, Milord.
expect
Even
that it
I'm
is to
blaming.
be.
That's why, Milord, I am suggesting it is me who is the worst sufferer. If the Order 9 Rule 13 proceeding continues for years together, they will be benefited because my execution case has been stayed. So why, Milord, they are in hurry? The learned judge is in hurry. Milord, allow me, Milord, to ventilate my grievance before.
Otherwise, you will say that matters are pending. The trial court is not taking up matters.
That's why I am before.
You will be coming here.
No, that's why
Expedite the hearing.
Milord, records that being
That
a
is what
decree holder,
exactly what you are doing, Mr. Mukherjee.
records that being a decree holder, Milord, I am rather praying before your lordship that allow me to place my section 24 application. By that time, at least the learned judge should not, Milord, take up, Milord, the hearing, because the learned judge is of the view he will.
That means, Mr. Mukherjee, only one thing. In a roundabout way, indirectly, I am staying on the ground of pendency of Section 24. You could have approached the learned district judge for that.
District judge I have approached on 3rd itself. The learned judge posted it on 20th.
Has to be, some time has to be given.
That's why.
Then
Milord,
the
protect
district
me
judge
for
on that
tomorrow.
date.
Protect me for tomorrow itself. I will, Milord, place it on 20th before the learned, Milord, district judge. If I could not get any order, Milord, my avenues are there. Protect me for tomorrow. I am being the decree holder. I am suffering. And it's my witness. The learned judge, I must say, Milord, he is, Milord, of the view that as if, Milord, Section 5 allowing is amounts to allowing Order 9 rule. In this case, it's not, really not.
So I give you liberty to file an application for adjournment. I'm requesting the learned trial judge to fix a date after 20th. Mr.
I have taken instruction, my lord. She is residing at the flat of
Item number 30.
35.
Yes.
I have taken instruction, my lord. She is residing at the flat. But my
Hmm.
lord,
Yes.
my lord, I have taken instruction. She is residing in the flat of the husband. My lord, kindly consider he is suppressing his salary by
You are
not
residing at the flat of the husband, this 12,000 which he is spending or 10,000 which he is spending for the loan has to be taken into consideration
My lord, he
as
is-
the alimony.
my lord, may I submit, my lord? He is presently posted as executive engineer of L&T Finance, L&T company, a construction company. My lord, I have searched out in the internet. My lord, average salary is 18 lakhs per annum. That is 1,50,000 per month.
1,50,000 per month, and you have also claimed 1,50,000 per month as maintenance.
My lord, 12,000 is awarded, my lord. Kindly consider, my lord, the amount.
Yes, rightly, because your statement is 1,50,000 and you have also claimed 1,50,000. That's your attitude.
My lord,
Rightly.
That was, my lord, wrong.
And you are enjoying the flat. So for residential purpose, that's taken care of. So what's the other things? 12,000, it's
May I serve and come back, my lord? May I serve and come back, my lord? But I'm saying, my lord, at least he should disclose his income. Lord.
wherever stated that his income is such and such. Where? What is the finding of the learned trial judge with regard to the income?
My lord, he has stated in his affidavit of assets that he earns rupees 60,000 per month, but my lord could not find, my lord, page 2, my lord, kindly see. At present, he is posted at Baroda under L&T as construction manager, and his monthly income is approximately rupees 60,000, though he did not file any of his salary slip to prove his claim. In at page 2 of the, my lord, order.
$10,000 you are getting as maintenance. Please see page 12, page 2. Bank statement proved that since May 2025, he is paying 10,000 per month to the petitioner as maintenance to banking transactions. He is repaying loan obtained by him to purchase the flat. Apart from that, he is paying 20,000. Oh, 20,000 to his parents. The learned advocate appearing for the petition. It is, however, made clear that pendants
I'm for the opposite party. Lordship, in 36, I have not yet received Vakalatama, only oral instruction, but 37 I got.
May I please, your lord?
You can use the microphone. Yes.
Under order 9, rule 30.
Dismissed.
Dismissed. Appeal confirms the dismissal. And
What remains in 227 then?
say,
Concurrent finding of fact.
no, subject to correction, my lord. Subject to correction. I want your lordship's intervention and consideration. Superintendent.
What's the infirmity?
That is my point.
What is the infirmity? Please tell me.
My lord. My lord. The infirmity is this, that no summon was served. I am the defendant number 1. I am the only applicant in order 9 rule 13, misappeal, and herein the petitioner only the defendant number 1. My lord, no summon was served upon defendant number 2 to defendant number 12. Under plaintiff, 1.5 decimals of land, a pakka structure, room that is occupied and used by the government, ICDCS, my lord, the child development project, and it is running for long years, my lord. And that 1.5 decimals is under my occupation, the defendant number 1 and 2. My lord, 2 is the BDO, duty cast upon the plaintiff, subject to correction, my lord. Duty cast upon the plaintiff to serve the summons apart from the 2 to 12, my lord. For me also, my lord, I am respectfully submitting that no summon was served ever. My lord knows by 2 mode of service, my lord. And none of the mode is available in the case record, my lord. My lord knows that negative need not be proved, my lord. I have stated that no summon served upon me. And it is the only evidence available in the LCR. My lord knows better than me. It is the only LCR. I cannot prove that no summons received by me.
They have to prove that summons has been served.
My lord,
There is no dispute with regard to that.
My lord, I am grateful, my lord. Neither the plaintiff stated anything in 2 orders. Only the learned court, trial court, and the court below recorded that it is presumed. It is presumed, it is maybe infer, these are words, my lord, when admittedly in the order that the AD card signed by someone, one AD card.
Who is that someone?
Not I.
Who is that someone?
I do not know. My lord, in my petition.
And who are you?
My lord.
Who are you?
My lord. I am the ICDS in charge of the room and running the vaccination, etc.
Who is the tenant?
My lord,
Who is the tenant?
my lord, kindly consider.
I'm asking you, who is the tenant?
My lord, kindly. I am academically, I am also asking my junior, my lord. I do not know what is written in the plaint.
No, I'm asking you. You must be knowing who is the tenant.
In the plaint, as yet.
No. You might not have, because you will not accept the plaint case. You will not accept. Let the plaintiff say anything. I'm asking your case.
My lord,
who is the tenant according to you? Or who was the tenant according to you?
I do not know what written in the plaint, my lord. I am therein for 20 years. I have the.
Who was in possession of?
I means, my lord.
I means yes.
I means, my lord. I am a government employee. I have been designated as a defendant number 1 by name, my lord. And at the bottom of my.
You are a government employee.
My lord. My lord. But I have been designated as a party defendant. My lord, for the government of West Bengal, my lord, defendant number 2 is available. No copy was served or directed to be served. in this revisional application to the BDO, I am the petitioner herein, and the last order was passed by predecessor in the chair, my lord. That is only a sub copy upon the plaintiff. My lord, we have sub.
Yes, the plaintiff is represented. You did not file the. She is not disputing.
Wakalatnama she will file, my lord.
Wakalatnama she will file.
I am not on that. I am not on that. My lord, let the suit be heard on contest. My lord, the plaintiff, they are in the plaintiff, my lord. They have designated other 11 private defendants.
Don't espouse the cause of other 11. You espouse your own cause only. Let other 11 come, then I will consider. Please espouse your own case. Please now kindly come to the judgment. What is the infirmity?
My lord, there is no government seal. Oh,
Please show me from the judgment.
My lord, and my lord, what? There is no government seal, although the defendant number 1 and 2 are the government.
Please show me from the judgment. That will be better. Yes.
There is no government seal, there is no bailiff service. There is only.
Please show me where it is the finding. Please show me that.
My lord, may I place, my lord, one. And my lord, I have repeatedly stated that there is a fraud committed by the plaintiff in causing alleged service, and there is no order 5 rule 20 at all. All these things stated by me in both the courts. My lord, kindly come to the page 35, my lord.
Page 35. Page 35 of?
Page 35 of the revisional application, first 30, item number 36.
33. What is the
36,
item?
36.
36 is?
Item number 36.
2575. 2575. You want to move 2575 fast?
4267.
4267.
Relating to order 21 rule 9.
Right, 4267. Yes, page?
4267, my lord.
Page?
My lord. My lord, page 35, my lord.
Yes.
My lord, on the first line, it is an application under order 9 rule 13. My lord, find that. My lord, thereafter, after 6 lines, the shoot property being one.
Read the judgment in its entirety. Please show me the infirmity.
I'm jumping, my lord.
Please show me the infirmity, the findings.
My lord,
What is your case?
Just,
What have you raised? What is the finding?
my lord, I'm not going to my application of any case.
Indeed not. Please show me the infirmity in the findings.
From the order, I'm showing what is really recorded. That is 1.5 decimals of land out of 3 decimals as alleged by the plaintiff. It is my occupation. I have constructed the roof in respect of the tile shed shoot property and has committed, and there is the committed fraud. That is our allegation. Then, my lord, kindly come to page 36. In the middle portion, second para, middle portion after 6-7 line, my lord. The condonation of delay of 808 days. My lord, the order passed by the learned trial court on merits on the order 9 rule 13, and the section 5 has not been so dealt with, and as if the section 5 has been considered and allowed. So I am not in section 5. My lord, thereafter that notice was duly served upon ICDS center headed by Mr. Bilanini Jana, my predecessor, they are saying, and also BDO Kolaghat, as according to their statement, plaintiff statement. Learned trial court recorded in the case. It says they failed to appear in the title suit, therefore the said was set for hearing as ex parte. My lord, kindly come to thereafter. Page 37.
Yes.
My lord, page 37, third para, bottom para, my lord. In the middle portion, the decree order filed title execution case number being 19 of 18, dated at so for execution of the decree passed by this court, so my lord. Thereafter, after 3 lines, judgment letter filed instant case for setting aside of the ex parte order. So, and the last line that there is no legal ground for setting aside of the ex parte order, and the instant case is liable to be dismissed.
This is the finding, my lord, in the envelope. The envelope returned to the LCR, my lord. The AD card returned to the LCR. My lord, what am I to prove? That is, everything is available in the LCR. My lord, the BLF report never been uttered by the trial court or by the appeal court. But however, I presume that there must be a government seal for service of court summon in the bailiff report and also in the AD card. My lord, there is a concurrent finding, my lord said, my lord. So, until or unless the LCR is considered by your lordship, my lord, I cannot prove anything beyond the LCR, my lord. I have no document to prove, and nothing is in the hand of the plaintiff, my lord. Everything is the LCR, and it was the learned trial court was the best judge to find out and to write down that this is the envelope, this is the AD card that is
So
available.
the lower court records is to be called for.
My lord, as your lordship.
Thank you. Yes, proceed further. Yes.
My lord, thereafter, as my lord said, don't look onto the depend upon the other defendants, my lord. My lord, page 39, last para, last line. My lord, kindly excuse me, I'm jumping, my lord. Excuse me, I'm jumping.
Yes, yes, please jump. Please straight away come to the point.
My
You
lord,
need not
please
place
hold
the entirety.
My lord, my lord. My lord. My lord, last para, order 9, rule 13, was filed. One being that the summon was not duly served upon the defendants, and the other that though the summons was duly served, and the defendant was prevented by sufficient cause by appearing when the suit is called for hearing, that is a party hearing. My lord, the main matter I will place from page 40, my lord. From page 40, my lord.
Yes.
And this, from here, these things.
You can place from page 40, third sentence from the top. From there you can place.
From
Yes.
the top.
Yes, from the top, third sentence.
That the AD card dated so and so shows that the summons was delivered at Paskura ICK Center and was received by one Mrinalini Jana. My lord, any private signature without any seal or any person signed other than Mrinalini Jana as Mrinalini Jana in the village area, my lord, it is very hard to admit that it is that Mrinalini Jana who died, my lord, who died, and such AD card has been recorded by the trial judge in this order, in this page, my lord. So I say that the AD card was not received, and the bailiff report was also not received in the state office. But I do not know whether it is addressed. My lord knows that as per the General Clauses Act, section 27, the address is also to be proved and the contents also to be proved, my lord. My lord, however, relating to that AD card, my lord, that Mrinalini Jana is disputed by us, and the said alleged AD card is disputed by us. We do not know, my lord, in the LCR whether any envelope is available or not. My lord, nothing recorded relating to the bailiff report and nothing about the government seal on the bailiff report is available either on the substation defendant number 1 or before the head of his defendant number 2.
Yes.
However, my lord, you will find that the AD card in the middle portion, my lord, the said Mrinalini Jana was ill, so and so recorded by the learned trial judge, and she was cancer patient and later on died, and the said said earlier, the AD card with respect that includes defendant are instituted in the court of law. In the court of law, as said earlier, the AD card with respect to the defendant number 1, my lord got middle portion. Defendant number 1, which returned to the court, does not prove that someone was not delivered. But I objected to the not delivered. If the AD card is came back, I do not know whether with envelope or without envelope. I do not know whose sign or with government seal or not. Does not deliver to the defendant number 1, which returned to the court, does not prove that the summons was not delivered, sorry, at the ICDS center. So this is my case, and thus the first ground for setting aside of the equity could not be proved. Could not be proved, my lord. What I will prove, my lord? That is in the LCR, my lord. Court is every time fingering upon me that I failed to prove. My lord, I have nothing to prove. Only I am asserting that nothing served upon me. My lord, plaintiff even not to prove. Only the LCR is the material. But the learned trial court in this order, my lord, accusing me that I failed to prove. I failed to prove in several occasions, my lord. However, my lord, thereafter, my lord, page 41, my lord. The second para, for fifth line, that the petitioner assumes the additional charge of the aforesaid ICDS center. It is presumed, my lord. Under presumption, I respectfully submit before your lordship, my lord. I am protected by your lordship, my lord.
Yes.
When the LCR is in the hand of the trial court, my lord, presumption does not come into play, my lord. The material is available in the LCR. My lord, by the presumption and on the basis of assumption, the learned trial court, my lord, misunderstood me and recorded that I failed to prove in everywhere, my lord. However, that the same stepped into the shoes of the her predecessor in chair. That is, I came in the said chair, and thereafter I am trying to protect the said structure, my lord. And thereafter, my lord, after one line, the present case cannot be separated with the knowledge of her predecessor in chair. Well, I most respectfully submit that nothing in the office. I came as a government employee, no paper was there. And when the court bailiff came to my place, my lord, after 808 days from the date of degree, my lord, then and thereafter, I came to learn about the said expertise degree, and then and thereafter, within 10 days, my lord, I prepared the Order 9 Rule 13 application with their advocate, my lord, and filed the same within 17 days. I have no intentional laches or negligence or delay, and nothing was available in my office or in the office of the BDO, defendant number 2. My lord, I stepped into the shoes in the said chair after the death of said alleged Mrilanini Jana. And however, it is written, my lord, thereafter, the petitioner failed to prove her case, my lord, after 4 lines, my lord. The petitioner failed to prove her case, her contentions by cogent evidence. My lord, what evidence in my hand? I have nothing in my hand, my lord. I am out of court. I was.
Yes, that I have followed. Yes, everything is in the record. It has to be considered.
The petitioner failed to prove, my lord. Thereafter, the order resulted, my lord. Order 9 Rule 13 for setting aside of the expertise order and deeply passed in case number so and the same hereby stands rejected on contest with respect to the OP number 1 and expertise with respect to the remaining OPs. This is the trial court, my lord. Did not believe me and accusing me that I have not produced any evidence. This is the trial court, my lord. Thereafter, my lord, page 42, I have filed the misappeal, my lord. Page 42, my lord, I have filed the misappeal. That is, I, the appellant hearing, my lord, and the plaintiff has been made defendant OP number 1, and there are the other defendants, respondents. Well, none are contesting in the appeal. Well, only plaintiff contested the appeal. Serve the copy. Thereafter, my lord, my objection is there. Their objection is there. And thereafter, my lord, I am not going to the pleading, my lord. But another thereafter, page 52, order 21, rule 97 was filed against me.
Forget about that. Please straight away come to the appellate court's judgment. You can straight away come to page 14, internal page 14 of the appellate court's judgment.
My lord, before that, my lord, Page 61. Page 61, that is order 21, rule 97. I am not.
Let us go to miscellaneous appeal from order 9, rule 13. Order 21, we will come thereafter.
My lord. My lord, internal page 4.
Those are facts. Findings, please straight away come to page 14.
But I have
Facts, don't repeat those facts.
Page 7, I want.
7, yes.
Observations of
These are the trial court's observation. You have placed. So don't repeat that. Please kindly come to page 14. It's the appeal court's finding.
I'm protected by your lordship.
I'm reading along with you, but I have proceeded
No.
something far.
But I'm not wasting time.
Yes. Page 14.
In that page,
With the heading service of summons, the court's finding.
in that page 13, my lord, for 1 minute. My lord.
In page 13 is the arguments. 14, the finding starts. Please kind straight away to 14. Because we are running short of time. It's a motion bench.
My lord, second paragraph.
Yes. Now motion, it has to be
My lord.
not a hearing matter. Yes.
My lord, 13, second
Yes.
paragraph, my lord. Initially, summons could not be served on defendant number 1. However, this is the admission of the learned.
I think better finding you will get at page 14. Please kindly come to page 14.
My lord, I'm coming, my lord.
It's
Kindly-
clarified.
in my-
Who has received on behalf of Minalini, it has been clarified.
I have not received.
You have not received.
My lord.
You are not there at that point of time.
My lord. I'm
Yes.
very good, my lord.
So
And
you are
there is
not
no
there at
seal.
that point of
I have
time.
no independent interest other than the office. There is no office seal.
That is what I am saying. You have not received. That's the finding. Page 14.
In 13 is something there. The learned appellate court recorded something in my favor that it is not received by me.
Yes.
And my lord, page 14. Page 14, bottom portion, my lord.
You will go to the bottom portion. You will not place the middle portion.
My lord, as your lordship, my lord.
Yes.
Summon the court's finding.
Yes.
That the court records of title suit number so and so indicated that the summons sent via registered post with AD to Milanini Jana. She has no independent right. No letter can be sent to Milanini Jana.
That I have followed. Yes.
My lord,
She has
neither
no independent right because she was the center in charge of that ICDS.
ICDS should be the defendant number 1.
Yes.
Plaintiff did not design the plaint in a proper manner.
Yes.
Neither I nor the Milanini. Now I have been designated. As I came to the chair, they have given my name or I have given my name as because there was no ICDS. My lord, section 80 notice. Section 80.
I cannot go into those. Please kindly
Just I am
finish.
indicating.
Please.
I have got your lordship as that. But
Please don't enlarge the scope of the order 9 rule 13. Yes.
that is true. My lord, in the thereafter, the learned advocate for the appellate, though relied on the decision of the Honorable Andhra Pradesh High Court, so judgment, dated 2023 on the point of non-service of summons upon the appellant, but the same shall not be applicable in the present case. My lord, no judgment applies subject to correction, my lord. I respectfully submit no judgment applies, my lord. Only the LCR record along with the government seals written by 2 mode of service.
Yes.
Was essentially required. My lord, what will be harm if I be added in, I be heard in on contest?
No, there is no harm
My
on
lord.
that.
My
Yes, that I followed. Yes.
My lord, thereafter this judgment and thereafter, my lord, the Honorable Calcutta High Court in case of Pranab Kumar Maiti and Tapas Kumar Bhattacharya dated 10/4/15 in CO number so and so would also not be applicable under the present case as the said decision deals with the executability of a decree passed by a court in a title suit. Moreover, the question of executability of a decree is not the matter to be considered in a proceeding under Order 9 Rule 13. My lord, I do not know why this is, the judgment is otherwise.
Yes.
The learned appellate court distinguished otherwise, my lord.
Yes.
An ambit of the application under Order 9/2013 is limited and restricted to a specific purpose, and the court has to see whether summons was served upon the defendant or whether the defendant was prevented by any sufficient cause to appear before the court when the case was fixed for hearing. My lord, I was not aware about the suit. I was not aware about the decree when after 808 days after the alleged ex parte decree, somebody came to my office. Then and thereafter we came to learn that a degree has been passed. Matter section 5 not been dealt with. I am not alleging anything about the section 5. I am on the main merits of the Order 9 Rule 13.
Yes.
My lord, thereafter, page 15, my lord. Thereafter, some judgments has been recorded. In this point, the court relies on the legal precedents reported in so my lord, those judgments are different. I am based upon harping upon the actual material available in the LCR. That is the main material of the Order 9 Rule 13. And that is the learned court was in hand. The appellate court also did not call for the LCR to examine the said LCR whether there is any government seal or not. My lord knows in the read jurisdiction or any other thing, the seal is very much essential in the administrative law, my lord. And any person, his
Individual capacity.
individual capacity or signature cannot be compared even like other private defendants in the civil suit. In as per the evidence act.
Yes.
The seal is very much essential, but signature is not such essential, my lord. My lord, thereafter, in the said paragraph, after 4 lines, the summons was properly addressed. I do not know. I do not know. Copy of the summons was not available in the LCR. How court is presuming that the summons is properly addressed?
Yes.
Because copy of the summons was not in the LCR on the said date of order. However, the learned appellate court recorded these things and he did not call for the LCR. In spite of that, his recording summons was properly addressed and sent by the registered court under section 27 of the General Causes Act. Read with section 114 of the Evidence Act. Well, in a Supreme Court judgment, Supreme Court is saying that not only the envelope, not only the address, but the contents are also to be looked into. Well, I will place 2007-8 SCC, my lord.
Yes.
Considering it creates a presumption, my lord. This is the word, my lord. I am very sorry, my lord. Presumption cannot be play against me, my lord. Respectfully, I submit, my lord. The material is available before in the hands of the court, my lord.
Yes.
Presumption, that is the main objection. And the AD card envelope, I do not know whether addressed to my office or not. And the AD card, even if anything is there with some signature, spelling of some name, that is not the material. The seal is there. My lord, 2-3 months can be spent by the trial court to hear the suit on contest. My lord, they have no right title interest. Plaintiff has no right title interest. We have constructed, the government constructed the said room, and 20 years the vaccination and etc. are going on. My lord, these are the allegations by the court against me. My lord, I cannot oppose these allegations. I cannot contest against the order or observation.
Because records will speak for itself.
Record will speak for itself. And
Yes.
your lordship is the best judge at the moment, and the trial the matter can be decided by your lordship by call for the LCR or by setting aside the impugned orders, my lord.
And by directing the suit to be disposed of expeditiously.
My lord, I have no objection if I be defeated by hard-earned contest. My lord, thereafter, my lord, all similar things are written in the subsequent paragraphs, my lord, possibly has.
You need not repeat if that is same.
Listen, my lord.
No repetition.
The
If you want to cite any decisions, you can cite that.
My lord, thereafter, my lord has gone through that. But I have several other things upon the as the assertion made by the learned court or the appeal court doesn't apply against me, my lord. All right.
Yes, for what proposition?
It is relating to E portion, my lord. The claim that the defendant did not accept the service or could not be found. Defendant could not be found, my lord. Materials required to be substantiate.
Please give the citation 2007.
2007, 8 ACC 751.
751 paragraph.
E portion, E.
Head note E.
My lord, head note E, my lord. My lord, kindly allow me to give the Xerox copy of the judgment.
Yes.
My lord, I respectfully submit, my lord, order 5, rule 17. Nothing recorded by the trial court, nor by the appellate court.
Yes, because this, according to you, is that only notice cover is not sufficient. Summons, what is the
My lord,
contents,
I'm
that
grateful,
is
my
to be
lord. That
considered.
is as per the Supreme Court, my lord. My lord,
Anything more?
1 minute, my lord. Order 5, rule 19.
Not followed.
Not followed. Service not accepted by the learned court or by the appellate court. Never considered, my lord. Order 5, rule 20, my lord. No substituted service. Court is in a hurry to pass an expertise decree for some reason or other. My lord, another, my lord, subject to correction. Another, 211.3 SCC, 545. My lord, it's relating to order 9, rule 13,
2011, volume 3 SCC,
SCC 545.
paragraph.
Paragraph, my lord, on 3 C, D.
Head note.
Head note, head note. I am not going into the merit. I will give the Xerox. I could not.
C, D and
D and G.
C, D, E. Yes, give me.
And page 46, first head note, my lord. Kindly, my lord. My learned trial court could have take a lenient view to take me and to proceed with the suit. At least against me and other left other the defendants. When I am shouting in the court that kindly hear me, give me a chance to file 2 pages WS. Nothing more.
Why 2 pages? When opportunity is
My
given,
lord,
you can
because
5 pages also. 2 page, 5 page, 7 pages, same.
My lord, so far I want to submit that I have no independent interest, and you, the plaintiff, is not the owner of the property as per the record of rights. And
I cannot go into that here.
my lord, I cannot submit it.
Let me see. If it is remanded, then you get an entire opportunity. Yes, anything more?
1.5 shoot land relates to me, is the government property recorded in the
All right.
government's name.
Yes.
My lord, I'm grateful.
My lord, first lordship will kindly come to the misappeal judgment. First lordship, let me say he has not annexed the original certified copy of the Order 9 Rule 13. So
Application or
no, the
order.
order passed only of the misappeal. In this revision of
trial
application,
court certified copy is not there.
not there. It is not in
But
law.
nowadays that procedure has been.
Maybe, but lordship, it should have been. On merit, my lord, kindly comes to page 13 of the misappeals order, lordship.
Yes.
Here in detail, lordship, the learned lower appellate court, the first appellate court has discussed, lordship, how the summons were served.
Page 13 entirety, page
Yes.
14 after the heading service of summons,
Yes.
that two paragraph.
Yes.
Then page 16 to first two paragraphs.
Yes.
Anything more?
And also, lordship, kindly see page 16.
Yes, page 16 first two
Yes.
paragraphs.
Yes.
Anything more?
No.
Yes, please
Yeah.
give me the judgment.
Do I need to place that lordship inspection report that his secret?
Inspection, she was present, attended, commissioner's report, minutes, field notes, signed. I've seen that. That is page 16.
Yes.
Yes.
Lordship, this is the commissioner's report. Lordship will kindly see page 1. That is the report of the local inspection. Here, Lordship, the second last paragraph. Thereafter, I went to the locality on such and such at 10, and I again served notice on both the parties. Local gentlemen who were also present at the time of my inspection warrant. Present plaintiff and defendant local gentlemen signed on the said notice in the field, and that notice is at page 30. Lordship kindly sees the second signature at page 30. Mrinalini Jana.
Signature is not very
Lordship,
legible.
here.
Page 13.
Yes. Lordship, right. The second signature, Lordship. This was the notice given by the learned
Yes.
commissioner.
This is not legible.
Then let me take.
But you don't have any other copy.
Yes,
You have a better copy.
then that is the better copy.
This is not under order 5.
Yes. Yes.
So, Lordship, she was aware about the suit, but despite that, Lordship, she chose not to contest, Lordship. So, my respectful submission is both the courts are absolutely justified in passing the order.
Any decision you want to rely upon? Yes. Yes. What's the other matter?
My lord, other matter is due to pendency of this case, my lord.
Yes.
The stay application was rejected
My lord,
The stay application of
in the execution proceeding.
order 21, rule 97, that was police help has been granted. Allowed.
police help.
Changed. Not challenged. That has been allowed.
My lord, unless I get into the suit, my lord, how can I contest, my lord?
Lordship, that is at page
My lord,
55.
we have tried for 4 times, mentioned the matter before Justice Omnaran Rai, my lord. Only one order was passed, but the matter fixed was fixed for it.
Now when is the date of execution?
Date of execution. Yesterday they obtained an order of stay.
What is the next date?
Oh no, Lordship.
Yesterday you are not there. Accommodation has been sought for on your ground.
I know, my lord. Today I am there. That is why.
So I have heard.
Yes. Then Lordship, I will pass the order today.
When is the next date fixed?
We don't have any instruction.
Then please give me a week's time.
My lord.
Uh,
100.
I'm appearing on behalf of the opposite party.
But written statement, Thika, last order, order 6 is written statement.
Alert, the defendant Thikatan, original defendant Thikatan.
Give me the written statement.
For a moment, just claim Thikatancy right that has been approved by the Thikatancy controller for the first time. Thereafter, they have raised objection. Again, a proceedings has been initiated. Thikatancy controller hold that the property in question is the Thikatancy land and the person claiming Thikatancy right, that is the defendant herein, is the Thika tenant. They have challenged this order before the learned LRTT. The Land Reform Tenancy Tribunal affirmed this order of Thika tenancy controller. Thereafter, they have preferred second appeal under writ jurisdiction before the Honorable High Court. Upon hearing, the division bench of this court was held that when the order has been passed by the Thika tenancy controller, on that very point of time, the amendment was before amendment, this order was passed. On that very point of time, the Thika tenancy controller had no jurisdiction to declare whether the land in question is the Thika tenancy land or not. And that's why this order has been set aside with the direction to remand the same to the Thika tenancy controller for fresh adjudication. In compliance of the said order, Thika tenancy controller issued a notice. This notice was issued on 3rd December 2025. Upon receipt
You are a Thika tenant according to you.
That order has been set aside.
No, I'm asking you. Your claim is that you are a Thika tenant.
Yeah, I'm a Thika tenant. Twice, Thika tenancy controller declared twice to me Thika tenant. And that order has been affirmed by the Land Reform Tenancy Tribunal. And ultimately, all the orders has been set
What is
aside.
the basis of your claim of Thika tenancy right?
I was a tenant, the defendant, original defendant, was a tenant in respect of land in the premises in question, and he was constructed a structure thereon, and he was paying and occupying the same by paying ground.
You have a document that land was given to you with a right to make construction thereupon. Any document
All
you
the
have?
documents I have filed before the Land Thika tenancy controller, and they have upon hearing, they have decided that order has been affirmed by the elected.
Now it has been set aside.
Now, yes, yes, I am on that point. The claim of Thika tenancy right has already been set aside. And under the direction of the Honorable High Court, the Thika tenancy controller initiated fresh proceedings, which was registered as Miss Case number 54 of 2025. Upon receipt of that notice, the defendant filed an application before the trial court below for amendment of written statement. That application has been rejected. I am challenging that order.
Please show me your written statement now.
Previous it is my humble submission that a fresh proceedings has been initiated, and all the orders declaring Thika tenancy right has been
kindly
rejected.
comes to paragraph 10. Your lordship's query, my lord, will set address there.
But
Paragraph 10.
My humble submission, a new proceedings has been initiated. Previous claim has been set aside. And after obtaining this notice, I have filed this application to incorporate those facts. I am not claiming my amendment application that I am a Thika tenant. Only to incorporate the facts that a notice has been served by the Thika tenancy controller for adjudication whether the land in question is a Thika tenancy land or not. I am only to incorporate this fact. Now the question, if the Thika tenancy controller hold that is
My lord, got it? Paragraph 10.
it's a Thika tenancy property.
Paragraph 10. I'm sorry.
If the
You are a senior advocate, Mr. Basu. Let him conclude.
If the Thika tenancy controller hold that it's the land in question is the Thika tenancy land, that decree passed by the civil judge will be nullity as per provisions of law. Now, these application to incorporate only this fact I am not claiming by filing this.
So according to you, by virtue of the amendment, you sought to incorporate the fact that a notice has been issued
Yes.
by the Tika controller upon
Yes.
you. You wanted to bring that fact. Anything more?
No, I am just incorporate these facts that
That application has been rejected.
that application has been rejected, wrongly rejected. That is my
At what stage? Trial commenced.
trial commenced. I have received
Argument.
the notice was
2012 issues were framed.
the notice was
Now it isn't fixed for argument.
All right, yes, Mr. Bose.
Yes, the earlier order 2025 I have shown on the last day. Yesterday minute I
I
have
have forgotten it. What you have shown on the last occasion.
Paragraph 10, he has admitted, my lord, in the written statement that he's a Tika tenant. He's a premises tenant, my lord. And the last day, I submitted, my lord, order dated 31st October 2025.
31st of October.
Yes, order 6, rule 17 was filed. First order. Order number 209. এটা দিন তো জজ সাহেবকে। It is his application. On his application, this order was passed.
This was an earlier application.
83, he had filed a return. In a suit for eviction 1991 instituted, he filed a written statement admitting, my lord, his status as a, my lord, premises tenant. Landlord-tenant relationship under 17, my lord, at that point of time, the law prevalent, my lord, that has been determined. Everything has been suppressed. দেখাচ্ছি সব দেখাচ্ছি
Yes.
Yes. Then, my lord, in respect of the another, in the same property, another room, the decree of eviction has been confirmed by the High Court in a first appeal. He is between the same parties. And in paragraph 10 of the written statement, which your lordship was asking for, yes. Paragraph 10. The defendant says that the plaintiff is not the owner landlord of the suit premises. Defendant does not know Alok Niranjan Pal. Alok Niranjan Pal was or is that the landlord of the defendant in respect of his tenancy such and such. The defendant states that he is a monthly tenant under Krishna Bihari Lal in respect of one room such and such. Monthly tenant such and such. And then the plaintiff is not entitled to claim rent from the defendant, landlord, such and such. The defendant says there is a relationship between the landlord-tenant. The defendant, after appearance in the suit, filed an application under Section 72 of the West Bengal Premises Tenant Act, praying for determination of the disputes as regards relationship with landlord and tenant. Such disputes may not determined by an order dated September 2, 2011. 15 years have passed. Kindly see is unchallenged, affirmed. Then, your lordship, when, my lord, he filed the application under order 7 to 11, that was also rejected by an order dated, my lord, 22nd April 2025. Judge Sahib ke din order. The catalogue of suppression is endless, my lord. I appreciate his perception and selective amnesia, but this is not tolerable, my lord, at this moment. Kindly seize the order of your lord.
I could not understand.
What
was your submission, Mr. Bose? I could not. Understand, Mr.
My lord, I withdraw. Kindly, my lord, your lordship's order 7 to 11. Order 7 to 11. 22nd April.
Anything more, Mr.
No,
Bose?
my lord, so this is, my lord, and my lord,
This application under Article matter is going on.
no, it's taken, it will be taken up. Next matter, next item.
All the previous order which has been shown that has been passed before 17th September 2025. On that very date, the Honorable Division Bench of this court set aside the previous orders. I am, by filing this application for amendment, I am not claiming that I am a Tika tenant. I am just willing to incorporate the facts that in compliance of the order, I am just reading the relevant portion of the order passed by the division bench. Kindly come to page 51, paragraph 32.
51.
51, paragraph 32.
Yes.
As per our above discussion, since the question of whether a land is a Tika land or not is to be decided irrespective of the facts whether there is any claim of Tika tenancy on such land, the scope of consideration now before the controller on the application of the writ petitioner is whether the land in question is a Tika land or not, irrespective of the question as to whether a person claims a Tika tenancy on the said property and or such question has been previously adjudicated. In any event, since the Tika controller did not have the power to decide such question prior to the 2010 amendment, that amendment was of 1st November 2010 and the order was passed in the month of August 2010. However, the previous adjudication would not have been taken within its conspectus. The adjudication now sought in respect of the character of the land in question. However, both the order passed by the Tika tenancy controller as well as the landed tribunal are in law in misinterpreting the interplay between the amendment of 2010 to section 5(3) of the 2001 Act. And ultimately, the order has been set aside and the matter is remanded to the Tika tenancy controller for proper adjudication. And in compliance of this order, the Tika tenancy controller issued a notice
Dated 3rd of December 2025.
3rd of December 2025. And I have filed this application
To bring on record that fact.
Yes, on 12th December 2025. I am not claiming that I am a Tika tenant. Nothing. I am just incorporate these facts. In an application under order 6, rule 17, it should be seen liberal.
This application under Article 2
time. So kindly have a look at.
Mr. Chatterjee, I'm keeping it tomorrow because some matters are fixed at 4 p.m. But you already.
That's why I looks into the impugned order once. 1
What?
minute, it's over. 1 minute. Kindly have a look at the impugned order. Well, if your lordship takes
412. 412.
takes 30 seconds, it's over. Looks at the impugned order. I will not even open my mouth.
Impugned order.
Yes.
Where is the impugned order? Nowadays, it's very difficult to get the impugned order, Mr. Chatterjee.
It's there at the beginning as well as right at the end.
Yes. Estate officer's order.
Yes.
Yes.
Have a look at it. Lord, the first day, section 4 notice. Second day, my lord, we pray for an adjournment that we will file our reply. We go, my lord, to the court and ask for an adjournment. My lord, it has been said that you have filed a written statement. Matter is over. No evidence required. I will pass orders.
Yes, Mr. Nag.
Then I was correct.
No, my lord, here, I think, my lord, the
same estate officer, Mr. Nag.
No, it's whole dia. It's
Same,
whole dia.
same estate officer.
No, the other matters are these matters are different. My lord, kindly allow me. No, my lord, there are two matters before your lordship. One, my lord, under section 4 that they have challenged here, and another under section 7.
7, I have not opened my mouth yet.
Section 4, Mr. Nag, are they not entitled to an opportunity?
No, they are. They are, my lord. My lord, I will give a concession to this. I have instruction. But, my lord, before your lordship goes there, my lord,
What concession? What concession you want to give?
My lord, it's not to be recorded.
Not to be
but
recorded.
My lord, here is the concession which I have talked to my client that they are willing to give, my lord, if lordship grants them 1 month time to the estate officer to dispose of both the 4 and 7, they will do that with giving whatever.
They have filed their reply.
Yes. To 4, yes.
You have filed your reply.
Yes.
In section 4, we did that.
Let us proceed stage by stage.
Yes, that's what I thought.
Section 4, you have given your reply.
Right now, the date was for evidence, but we have to give our evidence. Why? To show that we are not unauthorized occupant.
Correct.
And the issues will be framed.
No.
Now, what has been done here?
Not.
He says it's over. I will.
Where is that?
Right at the end. Last paragraph.
Well, that concession I am going to give.
It's
But
not a
before.
concession, it's my right.
No, then I have to argue.
4-2B is my
So
right.
this is which matter?
This is 2161. 2161. They are challenging the closure order dated 1st July 2007.
Yes.
Gandhi judgment.
This is the first part.
Hearing is concluded.
Yes. And that's the day, Lord, I filed my written statement. So I prayed, Lord, for time to give evidence with respect to why I am not, Lord, unauthorized occupant. That is a right given under 4-2B, not a concession.
What's the procedure, Mr. Nag?
Procedure, that's what. My lord, kindly.
4-2B.
My lord, first, my lord, lordship has gone.
Have a look at 4-2B.
এই পাবলিক প্রমিস
দেখুন তো না ঠিক আছে দরকার নেই বলে দিলি have a look at 4-2B and then looks at section 5. It's a procedure. It's a procedure, my lord, given under the law
to show cause that you have done.
Yes, and then
to appear on a specimen along with evidence and also for a personal hearing.
Yes.
So, Mr. Nag, you follow this procedure.
Yes,
I record only that.
Kindly. My lord, here. My lord, lordship has read the bundle. My lord, there's a legal question cropped up. Allow me to answer that.
No legal question.
No. It's a legal misconception they are under. I just want to clarify before your lordship.
Section 5. Yes.
That's the order under eviction. Kindly
yes, that they will.
After the evidence, they will consider that evidence.
Yes. So,
the estate officer. The estate officer.
Yes, estate officer.
Yes.
So this is the notice show cause. Then notice shall specify then the estate officer shall cause a notice to be served.
Notice served.
Judgment
I will not go before the estate officer. Once he gets the notice from his employee,
I go to the estate officer, I file my written statement, I file, my lord, my evidence to show, my lord, why I am in support of my show cause, and thereafter, my lord, they will consider the evidence and section 5 comes in there. After hearing, this is the simple thing. Nothing, nothing beyond that.
My lord, he has read the statute in his own way. Now, my lord, kindly have a look at, my lord, first the judgment, the recommendation by the Supreme Court, and then, my lord, I will argue on the amendment of 2015. My lord, kindly have a look. Lordship.
What is the next date fixed, Mr. Nag?
Well, date is, well, today we adjourn the matter.
Yes, but when is the next date fixed?
The estate officer
If you,
did not stick to
if you say yes, you will follow the procedures, it will be done. It cannot be in this.
Well,
It's a summary proceedings.
Well,
No doubt on this. But it's a précis, I think.
Well,
Précis of a précis, not a summary.
My lord, that's, my lord, kindly, my lord, I will not take more than 5 minutes. Now, my lord, lordship has considered the Bandi judgment while passing the earlier order. Kindly, my lord, have a look at, my lord, paragraph 33 and a copy.
Mr. Nag, then I can consider that if you want to argue, I will consider that. I will pass.
My lord, I want, my lord, today, my lord, what has fallen from your lordship, my lord, I came before your lordship without even asking, my lord, that we have the instruction to conclude both the proceeding within 1 month. But, my lord, kindly visualize the situation. What is the duty upon us? And then, my lord, record my submission, and then, my lord, pass the order.
Yes.
Now, my lord, kindly 33, my lord, if lordship takes 33 is the suggestion.
Yes.
Now, my lord, 33.3, kindly have a look. The principle of natural justice have to be followed while serving the notice. So this is under section 4 notice to be. Then, after following such and such, within 7 working days, send a show cause notice to the person concerned in the view of advance intimation sent such and such. Date of appearance before the estate officer for perusal of hearing, for personal hearing. As mentioned in the act, after show cause notice should not be more than 7 working days. The order of eviction should be passed as expeditiously as possible, preferably within 15 days. So that was the recommendation from notice to
Mr. Nag.
now, my lord, kindly.
Cannot. I'm not for a moment suggesting that you cannot do it by 7 days. You cannot do it by 15 days. It's not that. But you have to follow the procedure. The evidence and other things they have to lead. Consider, given opportunity of hearing, pass on orders. Do that within 3 days. No difficulty on that.
Why 7 days?
Do that within 3 days. No difficulty on that. But follow the procedure. You cannot say no. Yes, we have written statement. All right, hearing concluded. So if you follow that, we can also follow that procedure. Yes, we have filed. Yes, we have appeared.
I understood that there was a fault on our part, and that is why I came before your lordship.
That is what I'm telling you.
But two matters can be concluded. Don't record my submission. That within 1 month, both the matters will be concluded, giving them opportunity of hearing.
Yes.
Now, the issue that they are raising now, section 7 cannot proceed without.
I have not yet. We have not yet gone to section 7.
That I am ready to.
We are still in section 4.
Section 4, lordship.
So we could not proceed thereafter. 7 is long.
Both matters are there because first is 4, second is.
We are now in 4.
4,
5, 6, 7.
Don't record my concession. Kindly, my lord, record my submission that in terms of the judgment and amendment came into effect. My lord, we need to conclude a proceeding within 15 days.
You appearing for
I'm not on that you cannot conclude within 15 days. Can you say, since I have to conclude within 15 days, I will not give you an opportunity of hearing.
That's not.
I will not allow you to file.
My lord, I accept, my lord, what is fallen from you.
That is what I'm telling you. Why 15 days? Do it within 5 days.
Lordship.
Don't take 15 days. But please proceed in accordance with the law.
Lordship. He said that I read the statute in my own way. How was I wrong? Miller, let him also show.
Yeah, of course, I'm ready to show. I'm ready to show.
Show na.
এখন বলবো না পরে মামলা যখন আসবে পরের মামলায়
কেন বল না?
No, not now.
Let him show.
Don't record my concession, my lord. Don't record my concession.
day after tomorrow.
নেক্সট হচ্ছে ডে আফটার টুমরো, বইটা ফেরত দিয়ে দিন। ক্যান বি কেপ্ট হিয়ার?
এটা আমার বই।
Day after tomorrow. Great. Next. Yes, Mr. Das. Item number? You are appearing. For whom? Petitioner. আলাদা করে দেওয়া যাবে না? What is this matter?
Local investigation application has been rejected. And against that, I have preferred this divisional application.
Yes, what is the urgency? It has to be taken.
Urgency, my lord, can you see from the order?
In
itself?
file din. Which item?
Item number 50.
50?
My lord. Of today's list. Your lordship had this matter on last Thursday. And he directed to produce the record.
Yes, I shall produce.
Report.
Copy with me. All of the contention of the petitioner is.
What will happen tomorrow?
The date have not yet been fixed.
No, no,
my
I have
instruction.
on instruction on Friday. On instruction.
When?
On Friday.
Friday? Tomorrow I am keeping.
Tomorrow at, well, can you fix some time?
কালকে ওটা item.
Yes, I have no objection. I have no objection. 5 minutes, ma'am.
Yes, yes. Call the fixed matters. Yes.
Good. 3 years. 3 years, blood. I lost blood. It's a husband suit for divorce.
3 years?
3 years. I lost due to blood reconciliation and mediation. But my instruction is that initially it was for reconciliation.
Rajdeep Bhattacharya.
Failed. Rajdeep. Yes. My instruction is that, blood, that during the process of
Mediation failed.
though it's failed due to non-appearance of the parties, but on the day when the matter was heard by the learned mediator, both the parties are almost ad idem with regard to the terms of settlement. But subsequent date, due to non-appearance of the parties, both the parties, the mediation report is not submitted as failed.
Yes.
Now the learned judge is fixed for framing of issues. This application my learned junior has made not for the expeditious trial, but I have talked to my client. Essentially, my client informed that he is right now also, both the parties right now also is not settling, want to settle the dispute.
So you approach before the learned trial judge make that prayer.
That what happened, Milord, the learned mediation process that has been done before the trial judge, Milord, somehow, Milord, that's the hindrance where the parties are not being able to settle down.
So what do you want?
I want your lordship directs me to serve, though I have served, but still direct me serve, Milord, so that Milord, this can be done over here also. But otherwise, Milord, my prayer will be expeditious trial. The last day.
I'm directing the expeditious trial. I will also give you liberty. You can approach the learned trial judge. If you want to mediation, you can approach.
My instruction is thrice, Milord, it failed over there due
Then
to
I
that.
think it's better the suit is to be expedited. Nothing stops you, Mr. Mukherjee, nothing stops you from referring to mediation if both the parties jointly approach.
That's why, Milord, if I can serve and come back,
Here
this
it
can be
will
done.
this application under Article 2.
I am applying for the petitioner in this matter. It is expeditious hearing, Lordship.
Yes.
2020, the appeal is pending before the learned state consumer dispute redressal commission, Lordship.
Written notes filed.
Lordship, only written notes has been filed.
When it is fixed.
It is fixed on 3rd September 2026
For
hearing of it.
the learned advocate appearing for the this application.
Of a suit, my lord. I am the defendant in the suit. Suit for declaration of tenancy together with perpetual injunction.
What is the stage of the suit?
Preemptory hearing, my lord. I have filed a counterclaim for recovery of possession, my lord. Eviction and recovery of possession, but the plaintiff is deliberately delaying the suit from 20.
This application under Article 227 of applications are filed, no time frame. Yes, next.
Judgment suit, my lord, 2015. Yes, my lord, expeditious disposal of the suit and 7-2 is pending. Time frame we.
Who are you? Plaintiff. Plaintiff. This application under Article 227.
Time frame on the 7-2.
This application Yes.
Lordship, I am on behalf of the petitioner. I am behalf of the petitioner.
Yes.
Lordship, I filed the other suit for eviction by devocation of licensee. Lordship,
What is the stage of the suit?
SRAD is not complete. Suit is filed 2024 suit filed, but till today SRAD is not complete because
SRAD is not complete.
because PO is absent.
Because
PO is not, court is vacant.
then what can be done? This application under Article 227 of the Constitution of India is at
So
the
kindly grant to direction.
is yes.
Sure, my lord. My lord, I am praying for expeditious hearing of miss case number 44.
What is the miss case for?
For police assistance in title execution case, my lord. My lord, defendant, my lord, lost in eviction suit.
Miss case under what provision?
My lord, eviction suit filed by the plaintiff petitioner, my lord,
Miss case under what provision?
for police assistance.
This application under Article 2.
Of eviction of licensee. Lord, the suit was fixed for ex parte hearing. I filed my affidavit in chief. Thereafter, I took out an application for vacating of ex parte hearing, and Lord, now the WS is on record. Written statement is on record.
You will find in the last order on 21st of May 2020.
That application has been disposed of.
That application has been disposed of, my lord. Now it's fixed for evidence.
Fixed for evidence. This application under Article 227 of the Constitution. For which is pending.
Difficulty is that they are made undertaking to pay in a different suit, but they are not paying and
That's-
taking all these territory tactics.
I am appealing for the petitioner. The
Yes.
petition suit was filed in 2020. Thereafter, the respondent number 1 was first entered appearance in 2022. The respondent number 2 entered appearance in 2024. Thereafter, all the respondents appeared in 2025. Till date, there was direction to file written statements. Written statement was not filed. The next date,
Injunction application is still pending.
injunction
This
application.
application under Article 227 of the Constitution.
Petitioner, my lord, this suit is at 8 case of the custody of minor daughter under the Guardians and Wards Act, my lord, which is pending since 2024, my lord.
Application under Article 227.
Lordship, the title suit has been filed in the year 2021, Lordship. I am praying for expeditious disposal of the same, Lordship. It is at the stage of hearing and the next date fixed is 26th August 2026.
For what?
Analogous hearing.
This application, analogous hearing of what? This suit along with?
The suit filed by the opposite parties, Lordship.
This application under
expeditious disposal. I am the appellant in title appeal number 14 of 2017, pending before the learned additional district judge, FTC Court, Kalna. The matter is pending since 2017, and this suit has been filed for eviction of the defendant in title suit number 33 of 2009. I am the plaintiff, I am the appellant present.
What is the next date fixed?
20th of November 2026.
Regular presiding officer is not there.
Not there.
Then?
Before previous date, he was present, my lord.
Now presiding officer has joined.
Only on 15th of July, he wasn't present.
What is the next date fixed?
20th of November.
This application under Article 227. Yes.
The one partition suit is pending in Lane Talco Senior Division at Diamond Harbour since 2020. Both petitioner is a senior citizen and aged about 80 years. They filed a partition suit against opposite parties of their father's property. Now father is dead now. Out of the 6 defendants, 5 defendants is already appear and they filed their written statement.
Service is not complete. Newspaper publication.
The newspaper publication was already complete, my lord, as per the court order, my lord. Kindly see the page number.
This application under Article 220. Not today, next.
I am praying for expeditious hearing of partition suit of 2022.
Partition suit.
Yes.
What is the stage?
Yes, my lord.
Order 39, Rule 1 and 2.
Yes, my lord.
Is pending.
Yes, is pending, my lord, and defendant, my lord,
This
filed.
application under Article 2.
Defendant, my lord, prayed for time to file amended WS.
This application under Article 227 of the Constitution of India is at the instance of the Not today, next.
I am for the petitioner.
Yes.
It is filing 2024. Since then, Order 39, Rule 1, petition is pending.
This application under Article 220.
Hundred six under second note. Under 13 is the date before fixed before the
206 under second note. Yes.
13 is the next date, my lord, for execution. Preemption.
Execution of what?
Preemption procedure.
Hand over the possession, you succeed, you get back. That's the easiest thing.
Content of rehearsal. Point is, my lord, whether the partition is done or not, and I produce the registered deed of partition, my lord, that has not been accepted on the ground. The court has said that it is a pukur, therefore there is no, it cannot be any partition. Although I
Cannot be partitioned.
it is not the pukur, it is pukar. That is my point in this.
Pukur Park can be partitioned, Mr. Partitioned. Let me see what can be done. This motions.
Actually, when a second appeal was filed by some other. Second appeal was filed challenging the dismissal of this appeal. Subsequently, I filed after withdrawing the second.
This difficult upgradation, this thing, Mr. Mahato, it's very difficult. Because regular motions, none is pending.
That's true. But after the change of determination, my lord was there. Thereafter change. As soon as it was changed, again.
What can be done? It's very difficult. Current, pending, both it's very difficult, I'm telling you. Because yesterday also I was here till 5:40. See today. It's very difficult because otherwise current will be kept pending. And then he will be mentioning from the current matters. It's difficult because those who are pending, what were you doing? Why did you not mention it earlier?
Yes, I have mentioned it before Justice Raj Malad, when Malad was in circuit bench, I mentioned it.
Not circuit. There are previously before.
But it was before Justice, I have mentioned better. I mentioned.
Then
3, 4 matters, 5 matters. So many new motions.
so many. See the number of the new motions daily. It's difficult and most of the matters are contested.
Now new motions are being taken up.
But most of the matters are on KVA. So both parties are there. So it's difficult because it takes some time and I also take time to, let me see what can be done because tomorrow, because the difficulty was 2 dates I could not reach this upgraded matters. That's the difficulty, because some matters yesterday 2 fixed matters were there from 3:30 onwards. So that continued. So otherwise it could have been there. Let me see, because one group I could conclude. So it may spill over after 4:30, provided you are there.